I might watch the live stream.
Good morning, everybody. We're starting day 3 of these hearings into the proposed Otago Regional Policy Statement. I've got to start with the formal health and safety briefing, which will be very brief. And essentially, we'll just ask you, we'll advise you that toilets and bathroom facilities are available outside in the corridor to your left. Where you came in, evacuation and emergency procedures, fire, earthquake, same exit, and please vacate outside, obviously, and assemble at the Spate Sale House and stay there until the ORC warden has completed their reconciliation duties. And if you require any assistance during the hearing administrator is Kate McKinley, seated at the left-hand end of that table to my left. So with that briefing and the admonition to please make sure your cell phone's off, we will commence with the Otago Regional Council.
Good morning. We move now to the introduction general themes section of this hearing, and Ms. Boyd will be the planning witness in that respect. But before she begins, there's a theme which by Mr. Garbutt in submission to Needham City Council yesterday, which it might be appropriate that I pick up on because it segues nicely into this section. And he questioned invited you to question the use of the word avoid in this proposed RPS, and also the phrase or the words avoid as a first priority. And I'd just like to elaborate on the Regional Council's position in that respect. The purpose of national and regional policy statements is to set a policy framework, either nationally or regionally, and the intention of such a framework is to provide direction. And so the use of directive language is necessarily inherent in the policy statement making process. That doesn't mean that it's not the task of the panel to consider whether the word has been used correctly in some cases, or whether on the merits different phraseology is better to achieve the purpose of the act or to give effect to the objectives which is contained in the proposed RPS. But it doesn't mean that directive language is off the table. In fact, it's right on the table, because the purpose of the RPS is, amongst other things, to be given effect to regional district plans, and if the RPS is nothing more than a set of aspirations or a lot of wishful thinking, then it's of no use at all at that level. And likewise, an RPS is to be considered in determining resource consent applications and in determining notices of requirement for designations. So, direction, meaningful direction, it's at the heart of the RPS. It's why it's been, the statute requires it. And avoid, as Mr. Garbutt says, does mean avoid. I know the Supreme Court surprised everybody by saying in 2014 that avoid did mean avoid, and that meant not allow things which had specific adverse effects. And the court, of course, stated that the protection of the natural environment is part of sustainable management, and protection can't be achieved unless avoidance of certain adverse effects is contained in planning instruments made under the Act. Now, avoid doesn't mean that activities will necessarily be prohibited activities in regional district plans. The avoid attaches to effects, not to activities. So in some cases, it might be blindingly obvious that a particular activity will have undesirable adverse effects on the natural environment, and that constitutes a strong case for prohibited activity status in planning rules. But in other cases, it's impossible to predict what the outcome of a particular project or proposal or activity might be. And so a consenting process must be engaged in, and through that process, nature and scale of adverse effects can be determined. And in the case of an avoid policy, as the Court of Appeal said in the R.J. Davidson and the trust case, it's very difficult for consent to be granted. Now, moving on, as Mr. Garbutt said, the legal framework might change because of the pending Supreme Court decision in the Port Otago and East Link cases. We can only deal with that, as I said in opening, when that occurs during this hearings process. It's important also to note that the word avoid has been used in this RPS deliberately and selectively to try to achieve desirable outcomes in the natural environment and protect what is worthy of protection. Sometimes that is unqualified, and therefore this strict King Salmon injunction against adverse effects bites. Sometimes it's qualified where avoidance is the head of an effects management hierarchy, and if avoidance can't be achieved, then you move into remediation, mitigation, offsetting, or compensation, as the case may be. So you've got to look at the context also in which avoid is used. And finally, as the point Mr. Garbutt made, avoid is a first priority. Mr. Garbutt submitted that was equivalent to saying avoid. However, I submit to you that as a first priority is intended to work as a qualifier on the word avoid. It's avoid as a first priority is used in the urban form and development chapter. So that might be a matter which you should note and take up with the planning witnesses in respect to that chapter in a couple of weeks' time. But what I do submit to you is that it's intended not to act as strict avoidance, but to enable remediation and mitigation to be considered if avoidance can't be achieved. Now, there's almost a mantra of resource management practice of saying avoid, remedy, or mitigate. And that really adds nothing to Section 5, whereas the purpose of subordinate instruments such as national policy statements and regional policy statements is to tease out sustainable management and the elements of Section 5 and give them national and regional flavour, context, and effect. So what has happened is that, certainly in first generation policy statements and plans, is that the formula avoid, remedy, and mitigate has been repeated as a mantra, and in practice things have tended to default to the mitigation end of the spectrum, and in many cases the less mitigation the better. What avoid says to decision makers is that, in making their plans, considering consent applications, is that rather than the emphasis perhaps being on mitigation, it's on avoidance when looking at that formula: avoid, remedy, or mitigate. So I'll leave those thoughts with you because they're a matter that are going to come back. It's theme hearing from submitters throughout this process. I'm happy to take any questions, but otherwise I'm happy to move on to this board.
Look, those are very helpful comments and observations. Thank you, Mr. Logan. And I'm not sure if other members of the panel got any questions they want to raise at the moment. But it's a very helpful analysis, and thank you for raising it.
Boyd.
Tēnā koutou, Felicity Boyd, Toku Ingoa. I've prepared an opening statement which we can circulate now.
Thank you.
This statement provides an update on my understanding of the key issues in contention across the proposed Otago RPS since I prepared my Section 42A report and supplementary evidence on this topic. If I have not discussed an issue considered in my Section 42A report, I consider that either the issues have been resolved or the remaining issues are not significant. I would note at that point that we have a number of submitters wishing to be heard who haven't filed evidence, and I am unsure at the moment to what extent my recommendations address their concerns. Onto the purpose and philosophy of the RPS. The Council has committed to working in partnership with mana whenua to incorporate te ao Māori in the Council's work and to ensure meaningful engagement with mana whenua, which recognises the principles of partnership of the Treaty of Waitangi. The cultural evidence of Kaitahu Kia Taigo describes the deep relationship of Kaitahu with Te Taio, and this has underpinned the development of the RPS since its early stages. As Mr. Edward Ellison states, refreshes in policy such as this process provide opportunities to address past wrongs and reflect the growing maturity of our country in recognising our foundations grounded in the treaty partnership. In addition, the basis for the RPS was informed by a consultation with the community undertaken in early 2020 on the values of and issues facing Otago's environment. The most common values identified were healthy lakes and rivers, natural landscapes, access to the natural environment, biodiversity, and coastal areas. The key issues identified by the community were water health, agricultural practices, pollution and waste, residential growth, and invasive flora and fauna. In 2021, at the same time as preparing the RPS, the Council adopted its long-term plan 2021 to 2031, which contains the following 6 community outcomes, which the Council's activities seek to achieve over the 10-year period. Communities that connect with and care for Otago's environment, an environment that supports healthy people and ecosystems, communities that are resilient in the face of natural hazards and climate change and other risks, a sustainable way of life for everyone in Otago. Te ao Māori and Mātaraka Kaitahu are embedded in Otago communities, and sustainable, safe and inclusive transport. An environment that supports healthy people and ecosystems is described as all living things depend upon the health of the ecosystem they are a part of. Otago's ecosystems are diverse, healthy and resilient, and we protect and restore our threatened and Indigenous species and ecosystems. The Māori of Otago's natural environment is restored. Otago people enjoy healthy air quality, good water quality, and all the other ecosystem services nature provides to enhance the community's health and its social, cultural, and economic well-being. A sustainable way of life for everyone in Otago is described as Otago's people enjoy quality of life and make environmentally sustainable choices so that future generations can also enjoy a healthy environment. As a community, we minimise, reuse and recycle waste effectively and adopt best environmental practices to reduce our environmental footprint. Our communities are built to accommodate environmentally sustainable choices, and our industries and economy are viable for the long term while taking responsibility for their environmental impact. We all play our part in reducing our greenhouse gas emissions. I outline this background to explain the context for the development of the RPS and the outcomes it seeks to achieve. The philosophy underpinning the RPS has always been that, at a very basic level, The use and development of natural and physical resources should occur within limits or constraints that sustain the health of the environment for future generations. Some submitters still consider that the RPS is too focused on environmental protection and does not adequately provide for the use and development of resources and the social, economic and cultural well-being of people and communities. A number of submitters state that the RPS has applied the concept of te mana o te wai inappropriately by adopting it to manage the wider environment, not only freshwater. This issue also underpins a number of related arguments by submitters that the RPS does not adequately recognise the significance of or make provision for rural sectors and land uses, including appropriate timeframes for transitioning to a new land and water management framework, and whether there are gaps in the framework for managing rural areas, mining and other extractive industries, renewable electricity generation, including the proposal by some generators for an energy subchapter, and the national grid. There are varying levels of support for and opposition to these arguments amongst other submitters. Generally, those in support are organisations with similar interests. Moving to environmental limits. As outlined above, a strong tenet of the RPS is the concept of operating within limits. As a result, many provisions refer specifically to environmental limits or simply limits. As pointed out by submitters, this is not dissimilar to the recently introduced Natural and Built Environment Bill, which aims to enable use and development within environmental limits and targets. I've addressed this matter in detail in my Section 42A report and my supplementary evidence. There remains disagreement between submitters about whether it is appropriate and sufficiently certain for the RPS to refer to limits in this way. This is raised as a general issue by a number of submitters, but is considered particularly problematic in the IM and EIT chapters. Some submitters support my recommendation in supplementary evidence to use the term limit and rely on its ordinary meaning. Others support the concept of operating within limits and the use of a term such as limit, but seek greater clarity on what a limit is and how, where and when a limit is established. Others oppose the concept as well as the term and seek to delete limit wherever it arises, which alters the meaning and effect of those provisions within which it's used. Mr. Bathgate for Kaitahu has identified that in CE 05 clause 3 and CE M3 clause 7, limits has been replaced with constraints despite the recommendations in my supplementary evidence. I confirm this is an error. Both provisions should refer to limits, not constraints. In addition to the matters addressed in my Section 42A report on format, drafting and terminology, the evidence of some submitters raises a related issue of integration between the chapters of the RPS and whether there is sufficient clarity for users about which provisions apply in which circumstances. This is highlighted particularly in relation to the management of the coastal environment, Indigenous biodiversity and infrastructure. There's also concern about the division between this hearing process and the freshwater planning instrument, with submitters emphasising the importance of the final product being integrated and consistent, and querying how the processes will be managed to ensure this occurs. This was addressed by Mr. Logan in his opening legal submissions on Monday. Some submitters remain concerned about the use of particular terms in the RPS provisions, namely possible and avoid. Some submitters argue that while anything is possible, many things are not practicable, and therefore seek to use practicable instead of possible throughout the RPS. Others consider that as a result of the King Salmon decision, avoid has a highly directed meaning that can place significant constraints on lower order plans and other decision making, such as consent applications and notices of requirement for designations, and should be used sparingly and or with qualification. The issue concerning the habitats of trout and salmon appears to largely have been resolved. However, submitters have sought clarification about whether the new method I have proposed, which is generally supported by the interested submitters, will be considered in this process or the freshwater planning process. Legal advice is that this provision is within the scope of this hearing process. There are a range of other key issues that are either wholly or predominantly related to a specific chapter of the RPS, but often linked to the issues I've outlined above. and will therefore be addressed in detail at the hearing on those topics. At a very high level, these are whether higher order documents have been given effect, particularly the National Policy Statement for Renewable Electricity Generation, the National Policy Statement for Electricity Transmission, and the New Zealand Coastal Policy Statement. The extent to which the RPS provides for the use and development of Māori land, particularly in the NW and UFD chapters, the direction on resolving conflicts in the IM chapter, whether renewable electricity generation should be more explicitly provided for in the IM chapter, the appropriateness of provisions managing discharges to air, which provisions apply or not within the coastal environment, the extent to which the CE chapter places Māori and hauora first and foremost in coastal management, provides for a kia ora ki tai management approach, and properly recognises and provides for the kaitahu mana whenua relationship with the coast. Whether there is sufficient integration between the eco chapter and other relevant chapters of the RPS, particularly CE and LF, whether the provisions of the eco chapter are too restrictive, particularly policy 6, appendix 3 and appendix 4, the significance criteria in appendix 2 too broad, and the extent to which the chapter should reflect the content of the exposure draft of the National Policy Statement for Indigenous Biodiversity. And finally, the types of infrastructure identified as either regionally or nationally significant, and the appropriateness of the provisions in the EIT chapter for managing those types of infrastructure.
Thank you very much, Ms. Boyd. Just before I open for questions from the panel, I just wanted to say to you that probably in large measure, our perception of your report in terms of the definitions in particular is a learning exercise, receiving the exercise, if I put it that way, because so many of them relate to other chapters where probably some of us have yet to read, and so don't be too disappointed if there's not too much of a question flow towards you. So those opening comments, I'll see whether we might start differently today than Bianca.
Push the button. Look, just one question from me. You're referring in here to the long-term plan and the community outcomes. Which I think is useful. But in terms of preparation of the proposed RPS and the LTP, how did those processes overlap? Did they sort of mesh together in terms of identifying issues and the like, or were they quite separate? I'm just trying to explore what the interrelationship is between those two documents, particularly on human considerations.
Yes, good question. The RPS development was obviously led by the policy planning team at OSC, whereas the long-term plan is generally prepared by the strategy team. So they are different teams, but my recollection, and I wasn't involved in the development of the long-term plan, my recollection is that the consultation that occurred with, a workshop with councillors occurred to identify the regionally significant issues for the RPS to address, and that informed the consultation with the community in early 2020. And that consultation and the views of the councillors were then incorporated into the long-term plan as a reflection of the feedback received from the community.
Thanks. Should we have much regard to those, I suppose, community outcomes for the LTP for regional council type functions?
It's not a legal requirement for an RMA planning document to have any consideration of those outcomes. I merely highlight them to explain the philosophical thinking behind the RPS and what was occurring within the council in a longer term strategic policy space.
Thanks.
Thank you, Mr. Boyd. Just following on from Ron's comment on a couple of general questions, it has been quite difficult, and there's not a criticism of you guys, because they do, a lot of these issues relate to the chapters that we're going to get to, but more of a general sort of question around in your paragraph 10 in your supplementary, it's sort of related to the question Bianca just asked around that consultation process, and the a number of submitters have raised the point that in relation to those matters listed there not so long ago, there was another regional policy statement that addressed all those topics. And Mr. Logan suggested in his opening a couple of days ago, actually it feels like a week ago, 2 weeks ago, 3 weeks ago now, but that maybe the national planning standards have caused a few difficulties in how you might actually address some of those, which is, if that is the case, it's not ideal. For example, the mining issue that's been raised doesn't seem to fit anywhere within the headings of a RPS. Is that how you see it, or is it because there's quite comprehensive provisions for a lot of those things in the currently operative one, but it hasn't followed through here?
Yes, and similarly to the comment made by the chair, this has really been a learning exercise for ORC. Although the operative RPS is recent, there has been a deluge of national direction instruments promulgated since
On that.
decisions were made, which don't necessarily resolve conflicts between them. So it's been a complex exercise to consider those instruments as they come out and try to address them all in a way that makes sense. And fitting that within the planning standards framework has been a challenge. In my view, the planning standards don't prevent the establishment of additional chapters. It's quite clear in the mandatory directions that the council has discretion to create sub-chapters and additional chapters should it see fit. I think the reason that hasn't tended to occur is because the more chapters you add, the more complex the document tends to get, and the more issues there are with integration between chapters, which is already an issue with this RPS. And a lot of some of the direction that was contained in the previous RPS for some of these activities is not necessarily going to give effect to some of the newer national direction instruments. So I know there is a push from some submitters to see provisions from the previous RPS adopted in this version. I don't think it's acceptable to just adopt them without having gone through the planning analysis to determine whether they still give effect to the most recent direction, and whether they still achieve the outcomes being sought in this RPS.
Yeah, okay, thank you. But the only other thing was around your discussion around the limits issue and definition around that. Again, I think we need to consider the changes there in the context of the particular provision. It is a context thing, but I think in your section 42A, there was a discussion around threshold being caught up in that. The word threshold, to me, in a planning sense, that's different to a limit, because how I see that used is quite often it's used in planning to say, here's your threshold as to where you need to get consent or where you dip into a different category. So it is a different thing. And
Yes.
I think you had recommended taking that word out in various policies. I haven't come back to look at them, but is threshold used in that way in the RPS, or was it meant to be used as a limit or a restriction?
I think just by virtue of the fact that we have 10 reporting officers, there has been a bit of inconsistency about the way that various terms have been used. I did my best to pick up on all of those, but we had a truncated time frame. I agree with what you were saying in terms of the difference between a threshold and a limit. I tend to think of thresholds as being the point at which you flick into a different management category. And in a plan, that would obviously be your activity status, whereas to my mind, a limit is more
It's up there in the threshold.
Yeah, that's right. You might progress through a number of thresholds before you hit the limit. Yeah, that's my understanding. I think threshold, without going back through in detail, my recollection is that threshold was used primarily in the air chapter. And
So that'll come out of the national regulations around that.
yeah, I mean, I think that threshold is used in the NES for air quality, but not in the same way as we're using the term limit in this plan. So, yeah, I will double check that, but my discussion with the reporting officer for that chapter was we agreed that the term that we were trying, the concept that was being relied on was more of a limit than a threshold.
Yeah. Does it have any bearing on how we look at these environmental effects, cascades? Not the thing on. There's two different types, one from freshwater management.
Yes.
And one from maybe from the biodiversity graph.
So my supplementary evidence recommends that where the term limit is used in the context of freshwater, then the definition of limit in the NPS for freshwater management should be used. But that definition is not applicable outside the context of freshwater management because it relates to quality or quantity of water. And so I have recommended distinguishing that use from a general use of the term limit. And I think this discussion to me is one that is coming up in a number of chapters, and particularly biodiversity, about the extent to which the council is trying to align itself with a future management regime, and the pros and cons of trying to do that preemptively.
Yeah, things around that effects management hierarchy where all those sort of things come into play as well. Yeah. Okay, thank you. That just gives me a bit of an understanding of where this is all come from.
Mine is more just an observation, I guess, and things you've been clicking here. And I go back to legal counsel's earlier comments about RPS being aspirational. I mean, this is not just and in 5.5, where it's implicit here that the council is one of its aspirations is to Te Māori and Mātauranga Kaita who are embedded in community, a type of communities, which is quite aspirational, I think, in my view. But you also would have heard the discussion we've had over the last 2 days about Te Reo, the use of and definition of Māori terminology. And you're highlighting, I guess, because everyone's used it, of the term Te Ao Māori sort of fits in very well with the debate that's reading around in my mind, is at the very least, around Mātauranga Kaitahu, Mātauranga Māori, Mātauranga whatever. And there had been a pause in my own thinking earlier on that maybe one way around it is to use the word like a term like Te Ao Māori, encapsulate all that. We still face some difficulties, there's some challenges with that, as you're well aware. So I just wanted to just raise that again because we're going to come back to it at some point. I want to just keep it fresh in people's minds, and you're highlighting it again and help to do that. But other than that, I don't actually have any questions.
Mr. Boyd, I've got a number of points that I've just marked as I was reading your report, and so if we can just go to each of those. Paragraph 186 was the first one. You had a TBC at the end of paragraph 186. Was there something you wanted to add?
Yes, I know that too, actually. Yeah.
Just give me a moment to refresh my memory.
Around the carbon forestry.
Yes, I think I had intended to go back to that point and list the specific issues from the RPS that I considered to be relevant to the carbon forestry request, but I didn't do that.
Right. Is it something you need to do or wish to do?
I think the submitters interested in the carbon forestry or provision for carbon forestry have withdrawn the amendments that they're seeking. So I'm not sure that carbon forestry is as much of an issue now. And I think that submitter in particular, Waitaki District Council, I'm pretty sure has now withdrawn its requests for that issue.
Thank you. Next one was at paragraph, end of paragraph 205. And you concluded, for this reason, I do not recommend including an additional chapter in the PORPS specifically for mining. In my opinion, if alternative pathways are required, then they should be provided for within the relevant chapters. And as I was reading it, I just noted which are. So really, I was asking you if that was to be advanced, which do you regard as being the relevant chapters?
The reason for my statement there is that, and I'm relying primarily here on the evidence of Oceana Gold because they are the main submitter on this topic. The relief sought by that submitter is for a standalone set of provisions that address mining and extraction that essentially exempt them from the provisions in other chapters. And what I was seeking through my Section 42A report, as well as my supplementary evidence, was more analysis by that submitter of each of the exceptions that they are seeking and the reasons for those exceptions. And I haven't seen that in the level of detail that I was hoping to. So I have started to do that myself. There is a policy proposed by Oceana Gold that doesn't refer to specific chapters of the RPS because it's an existing policy from the 2019 RPS, but it refers to a number of topics that are dealt with in various chapters of this RPS, such as eco chapter for significant natural areas, outstanding natural features and landscapes, wahi tupuna. There is a list of areas in the policy that are more or less covered in similarly named chapters of this RPS. What I'm hoping that this hearing will tease out in more detail is, rather than the general proposition of an exemption from all of the protective provisions for mining and extraction, is it necessary for that exemption to be applied in the same way in every case, or can we look more specifically at each of those sets of provisions, biodiversity, natural features and landscapes, wahi tupuna, land and freshwater, coastal environment, and figure out whether a full exemption is necessary, whether there's some alternative amendment that might address the concerns of the submitter in a way that doesn't just override the existing provisions. That's really the tenet of my argument, is that that's the approach we should be taking to see on a topic by topic basis how to provide for those activities rather than just a carve out.
So is that best addressed in the slide? What's your from Oceana?
I think so. The planning evidence from Oceana Gold addresses a number of chapters which we haven't heard yet, and so I think I need to hear that evidence before I can settle on my recommendation.
That's their approach also, really.
In some respects, this general themes topic needs to be at the beginning and also at the end, because you can't really make a lot of progress at the beginning.
No, that's accepted. Just paragraph, page 62, paragraph 264. Just an observation, you had referred to in the second bullet point, it includes agriculture, which is not a land use. Are you aware that increasingly across the country, agriculture is actually being encouraged to be on the land?
Yes, and that's a good point. I am aware that there are land-based marine farming activities occurring. I was, probably incorrectly focusing on the water-based
Right.
parts.
Yeah. Okay, I just wanted to draw that to your attention. And next one is a bit over page 75. Now this links with, sorry, it's paragraph 320. So where you're making recommendations as to names, names being used. So Taiari, Paipori, and Poma, instead of what's in the plan at the present time. It seemed to conflict with the approach that you'd adopted in paragraph 313, 314, where you basically said too hard to do at the moment. We need to have a further, as I read your paragraph 313, 314, you were really saying that there would need to be a plan change, but in fact that becomes complicated because we've got too much on the go in planning workload, etc. And although the change could be implemented, progressively implemented alongside existing plan making projects, it's difficult over the coming years. And then suddenly, having read that, I saw that you made the recommendation that we in fact do those changes.
Yes.
How do I reconcile those?
Yes, that's a fair point. As an independent planner, I don't see any reason to continue to use incorrectly spelled place names. From a planning perspective, in the context of this RPS, I was convinced by the evidence of Kaitahu in particular about the importance of using those place names and in particular their importance to the culture of Kaitahu. Setting that, and that is the reason for my recommendation, because at the end of the day, I'm a planner engaged in this process on this document, and so that's my planning recommendation. An issue like this has a wider context, and I was alerted to the sensitivity of these renaming proposals by various people who reviewed my report, and I understand that there is not always there are sensitivities in the community when a council or anybody else starts to refer to places by different names. You know, the incorrectly spelled names have meaning and connections for those people in those communities, and so just going out with an RPS without really any lead in with those communities and just changing the name can be a little bit confronting to those communities. So I guess there's a planning recommendation which I've made, but that planning recommendation sits within a wider context of ORC's relationship with its communities.
So an alternative might be to use the Māori name as the correct spelling as the first name, but to have the old English transliteration really of the Māori as a secondary one.
Yes, and I think that's often the way that Edward Ellison referred to this, rather than immediately going to the geographic board and trying to officially change the names. It's often a softer approach to getting communities used to this change by using dual naming, and then eventually you get to a point where the community's moved on enough that you can drop that duality. And I think that's a good example of that is the Manahita Kia, where traditionally it was spelled with an I instead of an E, and the council has over time progressively moved to the correct Te Reo spelling, and I think that doesn't refer to both spellings now anymore because there's a general acceptance of the corrected spelling.
Just as another general observation, though, sometimes it's a question of knowing exactly which is the right spelling.
Yes.
It's easy for people to say, here's the right spelling, but 9 times out of 10 it isn't. Well, not 9 times out of 10, maybe 5 times out of 10 it isn't quite the right spelling. But it's a good point.
I'm conscious too that with some of these names. With the Manuhiri Kia, the changing from an I to an E doesn't really affect the pronunciation of the name. Whereas in the case of Taiari, Waipori, Pomahaka, they do change the way that the name is actually said, which is more of a change for those communities. You know, if you're used to being in the Taiari or the Waipori, you know, it is, there's more ground, yeah, there's more ground to cover.
Look, thank you very much, and thank you for the overall introduction. Thank you. On our list, we have Kaitoki again. Thank you.
We've seen the last of you.
Oh,
Quite
I wish that was the case.
asked those questions yesterday that you were.
That's right.
Ms. Bartlett has also got some points that she wanted to make this morning. She hasn't been able to make it up from Tapanui this morning. I think I sent thank you. So she'll be appearing remotely after I've done my little bit. I don't have a whole lot to say, but I expect there may be a number of questions for me on the issue that Commissioner Cubitt started to ask me about the other day. I do have some copies of my extremely brief. There were just two matters within the general themes that I wanted to touch on. It may be also that following the discussion that you've just had with Ms. Boyd, you might want me to make some comments on that question of place names and the use of place names, and I'm happy to do that as well. The main points I wanted to highlight this morning, the main topic I wanted to highlight this morning is the topic of the provision for mining and aggregate extraction. And I have addressed that in my evidence at paragraphs 56 to 63 and made a recommendation in relation to the urban form and development chapter in relation to that, which is right at the end of my appendix 1. Kaitahu Ki Otago opposed submissions of Oceana Gold and others requesting specific provisions for mineral extraction activities, particularly where these requests include full or partial exemptions from obligations to consider the adverse effects of these activities. Ms. Boyd's view is that it would be inappropriate to establish a bespoke policy approach to management of the effects of mineral and aggregate extraction, and I agree with her. Following on from the discussion that you've had with Ms. Boyd this morning, essentially I agree with her that the approach that is being proposed is far too broad brush, that it doesn't appropriately consider that there are a range of different types and different scales of mineral and aggregate extraction activity. There are a range of different types of effects, and there is a variety of national direction that relates to one or other of those different effects. And certainly my view of what's being proposed is that it doesn't appropriately recognise all those nuances, and because of that it essentially has the effect of assuming an overall priority to mineral and aggregate extraction that hasn't been justified in the evidence. As Mr. Fleck discussed with you the other day, mineral extraction activities can have a range of significant effects on the environment, and he provided examples of concerns about effects on the Māori of rivers and on the mahi kai habitats in the rivers and in the coastal environment. a long way downstream of the initial extraction activities. I acknowledge that there are locational constraints faced by mineral and aggregate extractors because they're looking for a particular mineral, and those particular minerals only occur in particular places. And I don't oppose recognition of those constraints in the RPS. However, I don't support extending that recognition to a general recognition of the importance of the contribution of mineral and aggregate extraction to social economic wellbeing, which is also part of what Ms. Boyd has recommended. I think that such recognition essentially inappropriately singles out that particular activity, that particular industry, that the recognition of the social and cultural the contribution to social and cultural wellbeing is not recognised anywhere in the RPS for any other activity. If you do a little search through the document in terms of that, it doesn't arise anywhere in any of the policies. So I question why we then start to come in and have a specific provision recognising the social and economic contribution of mineral and aggregate extraction when, I mean, there've been a number of submitters who have in their evidence talked about the social and economic contribution of a whole range of other activities, including food and fibre production, including rural industry, and a whole range of things. And it's not clear to me, that's not clear to me why mineral and aggregate extraction should be singled out. There isn't any national direction that gives any overall priority to mineral and aggregate extraction in that way. There is some national direction that provides for consent pathways for mineral and aggregate extraction where that has a significant regional or national benefit. That is more nuanced than the approach that the Oceana Gold and others are looking for here. They are looking for an approach which essentially says this whole industry is important, is so important that we should have our own bespoke provisions, and that is something that I don't think has been justified in the evidence. My concern about providing that sort of emphasis where there isn't clear justification for it is that essentially what that could lead to is that the economic and social contribution, recognition of the economic and social contribution of mineral and aggregate extraction, that recognition in the regional policy statement could lead to that factor being given inappropriate weight in considerations about how the environmental effects of these activities should be managed. And of course, in terms of looking at how the environmental effects should be managed, then there are a whole range of considerations that will come into play, including, the scale and nature of those effects. And I'm just concerned that reference, singling out the economic and social contribution of mineral and aggregate extraction could just prioritise that activity inappropriately in terms of the range of effects it has. The other point that I just wanted to make brief mention of is another point that Ms. Wood referred to this morning, which is the provision for trout and salmon habitat. I've only addressed this very briefly in my evidence because it is a matter that is not subject to dispute. I've addressed it at paragraph 111 in my evidence. Kaitahu Ki Otago opposed a number of amendments that were sought by Fish and Game to provide a framework for protection for trout and salmon habitat. The reason for that opposition was a concern that the framework that was being proposed by Fish and Game didn't appropriately reflect the, I guess, the hierarchy, the prioritisation that is inherent in the policies in the National Policy Statement for Freshwater Management, which says that the habitats of trout and salmon should be provided to the extent that that is consistent with providing for the habitats of Indigenous fish species. Our concern was that the framework that was provided didn't appropriately reflect that priority for Indigenous fish species, and that it could cut across there and inadvertently lead to circumstances in which providing for trout and salmon habitat could disadvantage the Indigenous habitats. So there were quite extensive discussions between Kaitahu Ki Otago, Te Aomara, Kaitahu Ki Murihiku, Department of Conservation, Fish and Game, and once we had sort of reached agreement on those points, further discussions with Ms. Boyd, and an agreed revised package has been included in Ms. Boyd's recommendations, and I'm very comfortable with those recommendations as they stand now.
You did say that you wanted to offer some observations.
I can
on
offer.
that.
I can offer those observations. Commissioner Crosby, you suggested the approach of referring to the correct place name first, and then with the more commonly used place name to follow that as a means, I guess, of educating people and transitioning them to the appropriate use. That is an approach which has routinely been used in, I guess, communications that we have had, particularly, and we've been involved a lot in the development of the Land and Water Regional Plan, and in the communications that we've had in terms of reporting to the Regional Council, or preparing, say, reports on the Manuhiri Kia, various things like that, and in presentations to public forums. That is generally the approach that we have used to try and educate people. What we have done is, where we have been referring specifically to the Kaitahu values and aspirations related to particular rivers, is that we have just used the correct form, the correct spelling, where we have been trying to, I guess, focused on ensuring that people understand what we're talking about, then we have used that dual form. I think my impression, since I have been working in this area with the Regional Council for Kaitahu, is that in the area of freshwater management, in terms of the place names of certainly the main rivers, including the Taiari, including the Matao, Clutha, probably including the Pomahaka, the Kako Nui, the Waihemo, Shag. There is a fairly high level of acceptance of those names now. There will always be people who don't like them, but in my view, there is sufficient acceptance of those names for it to be quite realistic, appropriate to be able to use those names in the in the regional policy statement. So I would certainly encourage you to use the correct place names for the rivers. I think where it comes to place names of locations, you get into the sorts of areas that Mr. Tipper was talking about the other day, and Mr. Higgins, that, you know, where you have a whole lot of issues sitting there as to, you know, whether those names are actually real names that mean anything, and whether there's an entirely different name that should more appropriately be used. In those circumstances, I think there is a much longer educative process that is going to be needed to shift things. So I think, and I think that maybe that those two types of considerations may be sort of sitting behind the, you know, those two approaches that I guess have arisen in Ms. Boyd's report.
Thank you.
Yeah, thanks. Just on that last topic, do you think there's an issue using place names in a statutory document that aren't gazetted?
I think it depends on the circumstances. And I think that is an issue in terms of specific locational names. But there are a range of other uses, and particularly, and I think the one that probably comes through most strongly is in the freshwater divisions, which again is sitting in a different process, but the freshwater management units that have been identified in Otago are freshwater management units that have been named by the regional council, or they relate to particular catchments, particular rivers. I don't see that there is anything that ties the naming of those freshwater management units to a gazetted name. I think that, you know, there is a lot of there is no constraint on the regional council naming those units by the correct name, which reflects the Kaitahu connection with those catchments and with those areas. So I think it depends a little bit on circumstance. I don't think that the geographic locations as such are very often referred to in the regional policy statement. Ms. Boyd might have looked at it a little bit more closely than me. I think it is the rivers that are most commonly referred to. In some of those cases, dual names have been gazetted. Certainly what used to be called the Shag River is now called the Waihemo Shag River. There is the Clutha Mata'o, which we would prefer to be Mata'o Clutha. Well, yeah, I'm not certain of the Pomahaka, but there, you know, you're not talking about a large difference in naming anyway. My instinct, talk about an instinct in these forums. I mean, my feeling is that there are not very many circumstances in the regional policy statement where the naming would be overly constrained by that gazetting. But I haven't had a thorough look at that.
One other, I suppose one other point around, just in relation to your discussion around mining and aggregate extraction. I mean, we heard from Transpower, and I've read some of their evidence around how they don't think we've given enough focus, or not we, but you know, the RPS, proposed RPS doesn't give enough focus to the transmission needs, including reverse sensitivity and other effects. And And also, I believe we've got evidence from the food and fibre industry, you know, wanting additional recognition for their industry as well. I mean, I'm just wondering if you've got comment on that. I mean, you're saying there that you don't think there's clear justification for singling out mineral and aggregate extraction, but we do have other industries wanting increased focus and not necessarily support for their industries through here, but just some recognition of the needs and values that those industries, I suppose, provide for the Otago region.
Yeah. I do have a view on that, and I have referred to it in some different places in different contexts in my evidence in relation to things like the transmission network and the electricity generators, and some of those, I guess, requests by people like Fonterra for recognition of, you know, regionally significant industry, etc., etc. The role of the regional policy statement is to provide for the significant resource management issues, which is identified in this regional policy statement primarily relate to the issues, the effects on the environment. So my view is that the regional policy statement needs to be largely focused on the effects rather than the specific activities that may address those effects. There are some distinctions to be made where there is national direction that needs to be reflected, or whether there are, you know, where there are Section 6 matters that need to be reflected, as we're talking about for the last couple of days. But primarily, I think the focus needs to be on the RPS is concerned with the significant environmental issues that have been identified and how we manage the effects that are currently being experienced, so that we actually can, you know, reverse, ensure that we have a healthy environment in terms of those effects. If you start to try and say, well, we need to provide for this particular activity or that particular activity or that particular activity or that particular activity, then you end up going down the path of having a whole lot of different sets of bespoke provisions, which undermines the ability to provide for the integrated management of those key environmental issues. And I have a real concern about that. I think there is a place for looking at the particular needs of particular activities, but that place is in the lower level plans. In some places, you know, and it depends on the activity, the nature of the activity, the nature of the effects. But I think that it is in the regional plans and the district plans that it is more appropriate to do that. I think the role of the regional policy statement is to provide for integrated management of the reported resource management issues. And if you start to try and have bespoke provisions for everything, then you don't achieve that.
Thank you.
Thank you. And this is the issue that I began on yesterday. I guess, Sandra, it's probably a philosophical issue. Felicity referred to the philosophy of the RPS, and you have twice you've referred to environmental issues, and you just referred to resource management issues there, which are two different things, I think. And the RPS is about resource management issues. And I would have thought that planning could actually provide for social and economic well-being of the community is a resource management issue. And I think what I've seen come through from those various groups that say we need some recognition of it is a recognition of the fact that, yeah, sure, we have effects in the environment, but we do all these positive things and we get slammed for doing take farming, for example, freshwater regulations come in, people tend to forget that, well, they actually provide us food and exports overseas. This is just due comment, don't take this, leading into the issue of mining. So, yeah, I have a slight different approach to that, and I think that's probably difficult for us to influence through this sort of process. So I understand what they're saying. I think the issue, what I'm hearing from the mining people, and you saying it shouldn't be recognised, I think there's quite a focus on one particular mine company.
Yes.
But I think I referred to yesterday, aggregates, everything we do in a community, infrastructure, everything is built on aggregates. You referred to it being 4.5% of the region's GDP. It's kind of irrelevant really because it underpins everything. And the point I think what's been made is we have this social and economic, and you referred to it as an economic use. Yeah, well, it is economic, but it's a very basic need. But it's constrained as to where those things are. And this is going to become even more important when I've recently bought an electric car. People think that they're environmentally friendly. Well, there's an awful lot of mining goes into building those batteries. Yeah, sorry, this is a philosopher. But it is relevant to recognition of what's happening in our communities. So what these mining companies and other people are saying is probably more so the mining fraternities, because they are constrained to where those resources are. We need them. Yes, they make money from it, but we need them. You look at farming as a contrast to that. There's lots of areas to farm, so they can avoid natural features, etc. Not so hard for them. It's a lot harder for mining companies. So I'm just wondering if you considered that sort of context in terms of that. I don't actually see an RPS as just stating the problems and here how we're going to fix them. We've got these other, because people and communities are a part of the environment. So you talk about everything being interconnected. So we do in some circumstances, but when it comes to this point, that seems to be forgotten.
I'm very aware of that context. My evidence is really responding to the approach that has been proposed and the evidence on which that is based and the resource management issues that have been identified in the regional policy statement. I don't disagree at all that certain types of aggregate extraction activity are essential to drive infrastructure, and there's a whole range of different types of activities in that mineral and aggregate sector. And there is a range of different roles of those different things, as there is in terms of other sectors. I don't disagree with what you say about a distinction between resource management issues and what I've sort of referred to as environmental effects issues. This RPS has identified that the key resource management issues are related to environmental effect. I don't think that means that it shouldn't provide for activities. I think the problem I have, which I think is the same problem that Ms. Boyd has, is that the approach which has been proposed doesn't actually clearly articulate what is, which are the circumstances that need to be provided for. And, it talks about a whole industry and one approach in terms of this whole industry. And it doesn't, yeah, there's not enough nuance in there, and essentially in terms of the types of things that you're talking about.
You might be right there, because I haven't gone into those provisions and considered, but it was more the philosophy of understanding where their requests are coming from.
Yeah, no, I totally understand.
Rather than provisions themselves, and there has been criticism that the RPS is just too narrowly focused on.
Yeah, I think a little comment about history, maybe.
We've already done the history.
Yeah, this is slightly different. This is in the Otago planning framework. There has in the past always been a very strong focus on economic activities and providing for those and enabling those economic activities. That is a reading of the current regional water plan, a reading of the partly operative regional policy statement, will, makes that very clear that the focus is on enabling economic activities. My understanding of the reason that I guess that the focus in this regional policy statement on the significant environmental effects that are being experienced is actually something that has been highlighted, and in part has been highlighted in the SRMR, I think, issue 10, which I've referred to, which is the one that specifically deals with the effects of economic activities on the environment, specifically recognises that approach of enabling and supporting environmental activities has had significant effects, and that those effects need to be addressed. So that, I think, that is the context in which I have made my recommendations. It is a context, I think, that the comments that Mr. Flack made the other day is really relevant to that.
Yeah, I understand that.
Yeah, and I guess, there was a question asked of Mr. Flack the other day in relation to that about the resource management processes in terms of the resource consents, I guess, that had been obtained, and how resource, how those resource consents processes had gone for Oceania Gold in the past. And Ms. Hunter refers to that a little bit in her evidence, particularly in relation to the natural character of rivers, and says, well, we've got consents for diverting streams in the past, and that seems to have been acceptable. So, so what's the problem? I mean, I'm sorry, I shouldn't be paraphrasing it that flippantly, but that's essentially what she says, is that we've got these consents in the past, and so they must be acceptable. The comments that I've just made about that historical context is that they have had those consents in the past, but they have got those consents in the past within a planning framework, within a regional plan, which there was no reference to cumulative effects in that plan. There was no consideration of effects beyond the immediate vicinity of the activity. There was a whole, again, and there was very much a focus on enabling activities. And I think that's just an example of, I guess, what I'm seeing as the shift in approach of this regional policy statement. And while I think that it is appropriate to consider where there may be particular needs that need to be recognised, I think they need to be looked at in the context of that resource management issue that's been identified.
I understand that. I guess one of my concerns, pretty much everything in society, actually, not just this process, is that when there's an issue, or when you turn your radio up and you get told to turn it down, they always turn it down too far and you can't hear it. So it's that balance, and I think I read in one of the section 42A, which might have been this points, that the RPS didn't have to consider balance, which I kind of find rather interesting, because it is enabling piece of legislation. It's all a human construct. I mean, the environment doesn't really care about us. We care about it. That'll carry on. So it is about communities. We look after the environment for our communities, and I understand what you're saying. We've gone too far in some ways. Anyway,
yeah,
that's what I really wanted to talk about around that.
And I think that, you know, and as I say, my concern is with that sort of broad brush approach, and I guess the way in which the provisions that have been proposed by the mining industry have, you know, that there doesn't appear to me to have been enough sort of thought about how the particular effects that are addressed in the regional policy statement, you know, how they need to be addressed if there is to be a bespoke approach. And I've said I'm not convinced there needs to be a bespoke approach. And just an example, in the provisions that they have proposed, which are, I think, in Ms. Hunter's Appendix B, there's a range of things there, but they talk about, well, an example, and this is relating, I guess, to those matters, to the, you know, the area of freshwater which Mrs. Beck referred to. They have said essentially that if it's not practical to avoid locating in areas, including when it comes to freshwater, natural wetlands or outstanding water bodies, then the adverse effects need to be managed in accordance in water bodies and natural wetlands in accordance with the relevant provisions in the National Policy Statement for Freshwater Management and the NESF. There are some provisions in the National Policy Statement for Freshwater Management and the NESF that provide a consent pathway for mining and for aggregate extraction. They provide a pathway. They don't include the full framework of what the direction is in terms of how the types of effects in relation to the water bodies and other things such as the functional location, that they do mention functional locational need, but how those different types of effects need to be considered together. The regional policy statement and following that, the land and water regional plan are the place where that direction will be provided. So to have a set of provisions that just says, well, we can just rely on the, you know, what the various national policy statements or national standards say, doesn't actually work, and it doesn't provide for an integrated approach to management of those activities that reflects the direction overall.
You may be right on the provisions. I haven't got that far yet, but in some of the stuff I'm seeing from other submitters does sort of look like stuff that should be in a district plan. But
Yes.
yeah, it's more about the philosophy around. Yeah. Anyway, thank you very much for that.
Okay. Right.
You don't know, Sandra. I just want to get your reaction to something I want to put up, and that is around the general notion of boldness. How bold do we need to be to do certain things? And partly in the context of the real issue that we've been talking about, and I understand fully your explanation as to how it's being dealt with here, that, you know, you use the right word, and if you don't, you know, there are times when you use both. But I can't help think of a very simple thing like the national anthem. Hine Mohi got up and sang it at a rugby match in English and Maori. That was bold. to the point that we all do it now. We've accepted it. It's just natural. We do it. So how much of this boldness thing do you think we need to be looking at in this review of the RPS?
I'm all in favour of boldness. And I think particularly in the Otago situation where there has been a very light hand on environmental management at the regional level until this sort of process has kicked off. I think there is a need to be bold because I think there is a lot of catching up to be done. And I think in terms of those sorts of examples that you've made in relation to things like use of te reo, it is very clear that if you just take timid steps, then it takes generations and generations and generations to make change. And and looking at that point of te reo, which is possibly a little bit outside the planning field, but it seems to me, having noticed in the last 3 years since presenters on television and radio started using te reo, there has been a significant shift, and that was a bold move. So I think, and that has had an impact. I think that if they hadn't been bold, that wouldn't have happened. In terms of the management of the environment, and I have been most involved in freshwater management in Otago in recent years. It is very clear that if we are not bold, then the remaining values of our water bodies are going to be lost. So I think, we absolutely need to be bold.
Because the challenge is as much one for planners as it is for anybody, but in this particular context, if I was to throw out a challenge, it would be to planners.
It's very challenging, and the points I think that have been made by a number of the, and particularly by the agricultural sector about the need for a transition to change are really important points. You can't, in terms of talking about boldness, you can't just say, right, we're going to change this now. From this point on, everything's going to be different. There absolutely needs to be a pathway set out for those changes. But there needs to be a beginning point for that pathway now. And I think this is what Ms. Bartlett will probably talk a little bit about in terms of interim frameworks and timeframes. There needs to be a clear path forward with the initial steps set now, rather than, well, this is hard and we need time to do it. So, let's just put it off while we all talk for a few more years about how we're going to do it. We don't, I think, anymore have the flexibility to do that. There is a great deal of information out there about the environmental degradation that has occurred over the last 30 years, and we need to address it. And that's what, vehicles like the National Policy Statement for Freshwater Management have recognised, and the NPSIB as well.
And I just want to cherry pick one particular word, and that word is Māori, where we would normally refer to water. It's more a way issue, is it more so than a non-way one. Would you agree with that?
I don't. My understanding of Māori is that it's not confined to the way. That Māori is a concept that applies in all parts of Te Kaiao. So that Māori also applies to the indigenous habitats,
Yeah, I kind of anticipated that would be because all through the submissions that we've had, there's been references to recovering Māori, protecting Māori, and all those sort of things. But I tell you what, in the non-water context, it's really difficult. I think you agree with that, wouldn't you?
Yes, and I think it's also difficult in a water context as well in some cases.
Water context, it's more identifiable than it is in the non, well, at least in my experience. I mean, we've had smart people come up with Māori measuring methodologies, you know, there's one in Hawke's Bay and there's another one in Rotorua. They've come up with we have a measurement.
Yeah.
And whilst I don't always agree with the measurements, but at least there are dimensions to, you know, there are things you can actually put your finger on to do that. And I raise this because I think the Māori issue is a bigger one than we're thinking about at the moment. It's more thematic than I think we've anticipated. And that's because of what I'm reading people saying, what they're writing about. And it got me thinking. And I'm thinking, have we underestimated this as but even if we have, can we realistically do something about it?
In the Indigenous management chapter, and I've referred to this in my evidence, there's a that's probably in my rebuttal evidence actually. There's a
I think in your appendix.
I think it may be my rebuttal to Dr. Freeman. There is an objectable policy, I'm trying to remember which, relates that I guess puts Māori in the context of essentially a sort of a hierarchy of priorities, which has some sort of similarities to the priorities in the National Policy Statement for freshwater management, and has also has some connections with Section 5 of the Act. So Māori there is bracketed with life supporting capacity, essentially, and is applied not just in relation to the why, but is applied in terms of the environment as a whole. That is, well, I mean, and I'm, you know, always learning more about Māori and working with Kaitahu and in terms of how they would like to approach this. But that approach of talking about Māori in the same breath as talking about the life supporting capacity of the environment is something which sits very comfortably with me because I understand those things to be very interconnected, and that in the resource management frameworks that we deal with, that is the appropriate way to deal with issues of Māori. I think the other point, and you talked about, you know, Māori measurement tools, my understanding is that certainly Kaitahu ki Otago don't favour those tools. That their approach is much more on the way in which you can, the way in which you need to look at Māori, understand what is happening to the Māori and what needs to be done to restore the Māori is through mātauranga, is through involvement of the people who hold mana whenua at the decision-making table, in terms of and at the table when the resource provisions are being developed, so that then there is a direct input by the people who know what they mean by Māori as to how that is managed.
Exactly. I may have mentioned it tools, but I didn't say whether I accepted it. Kia ora. Thank you very much, Andrew.
You'd be pleased to know that I have no further feedback for you on this general theme issue.
I believe that Ms. Bartlett is welcome on the screen somewhere.
Kia ora, Ms. Bartlett. At the moment, we've only got a very small picture of you. Are you able to increase that?
Good question. Am I? I don't know what to do.
No,
I also managed it yesterday, so I just need to work out which button to push.
no, it's all done. You're underway.
Brilliant. I'm pleased because I needed to have my documents up on the screen as well. I didn't want to fill the screen with me either. So yeah, morning there. I'm going to be really quick, probably, although just listening to that last exchange, I'm like, oh, I definitely have some things to add there. So probably my big thing was trying to work out when to have the conversations with you associated with different points in my evidence. So what I had thought was in relation to the interim frameworks, which actually just came up in your kōrero with Sandra, you know, that where necessary, I might sort of pop in and have something to say about those on a chapter basis. But that basic idea that was just discussed, I think is a really important one in terms of why that analysis of interim frameworks is in my evidence. It's just understanding what progress is being made and being very, very clear about what progress is being made while you're waiting to get maps or set limits. And you know, how clear are we about what is being achieved while we're working out you know, the limits of what's acceptable. So that's sitting in behind the reason for having a go at the scanning table and then sort of putting it back to the council and saying, you know, are there ways that we can improve this interim period, because the interim period still needs to be demonstrably supporting the achievement of those objectives and policies in the drafted RPS at the moment. Yeah, so just looking for clarity around how we know what we're achieving, yeah, while we go through some things. And I think that question around boldness is very relevant to this idea of the interim frameworks, because I think it's pretty clear that we've got one generation now from here, and if you take the certainly in the Ngaitahu Ki Murihiku iwi management plan, and from memory I think it's in the Kaitahu Ki Tākau one as well, that the 25-year resource consent duration is tied to the Kaitahu understanding of not binding the next generation from your decisions in this generation, so that and so that generational length has been set by the mātauranga of the tribal members down here as 25 years, and really that frame is quite that generational frame is really important for understanding the time we've got to achieve the restoration effort, if you like, whether it's water or biodiversity, or, and most importantly, certainly from tribal climate change strategy perspective, and the kaupapa in the Te Tangia Tauira iwi management plan, you know, the response and the investment we make now in environmental restoration is an investment for future generations to increase their resilience to climate change and species resilience to climate change. We've really got this generation. This is our shot, and so this RPS is sort of starting to set out that correct path through to, and that is why what you were just talking about, what Felicity was talking about, what Sandra was talking about, it's why it's so important at this juncture that the RPS has been recalibrated to give primary focus to the natural environment. You know, it's a really significant step, and you would have heard coming through Evelyn's quoted all that sense of urgency. So I think that is where we are, and we're so in a sense, I think that the intent of this RPS is to do a reset, recalibrate, get things on an appropriate partnership footing, an appropriate footing for the investment in the natural environment, and on the understanding that that investment is going to have important flow through benefits for well-being this generation and into those that follow. Yeah, it's the guts. So I suppose that's my comment on interim frameworks. And I may, pop up to clarify my thinking as we worked out yesterday. I did need to clarify what my table meant in relation to the MW chapter references. So I'll do something similar as we go through the different chapters, looking at those interim frameworks and what they're up to. I perhaps will swing back to the Murray discussion. If I just keep going through, you'll see there's a big passage in my evidence around dams and weirs, and I'm just trying to work out when to have the conversation with you, because obviously there's a definitions element in that section of my evidence, so I could be having that discussion tomorrow in relation to definitions. Presumably that could happen tomorrow, or in the context of the hazards chapter. So there's that aspect of the dams and weirs issue, but there's this broader aspect that I'm highlighting around the visibility of addressing this issue through the RPS. So this is slightly different to the discussion that you were just having around mining as a use. So I accept that sort of dams and weirs are a use, or they're an activity type, and you've just had a big discussion around to what extent activities get something specific. This is a bit different. This is really about, my point is really about wanting to see those issues that are highlighted, particularly obviously in the RMIA section, that visible analysis of how they've been addressed is in the different chapters as you go through. And dams and weirs at the moment are invisible, and the analysis is not sitting there in the Section 32 report to help understand consciously what has been done about this issue. It may well be in sort of inherent in the outcomes that are being sought, say in the land and freshwater chapter, but not just there, in terms of the kind of issues that arise from dams and weirs. So really what I'm looking for there corresponds with what I'm looking for in the other wee notes on the issues of significance that have been raised. I want to see and not have it left silent how the issue has been dealt with in each chapter, what dimension of the issue is dealt with in each chapter, and so that relationship between the provisions and the addressing of issues. And I find I'm particularly sort of honing in on this because I've certainly seen documents and planning instruments in the past that have sort of stuck a whole heap of issues at the front, and then you can't really see evidence of them being addressed. I think if we can be explicit, it's an assist, and we don't have to work that out at the next tier down. And I think that's quite important. And the dams and weirs just really stands out because you do have in the section 32 appendices, you know, common references to these being, well, they're sort of like the elephant in the room in a lot of ways. And yeah.
If it assists you at all, Ms. Barton, it would be most helpful to us if there are major issues arise out of particular definitions that you want to address in chapters, that would be suitable for us, because it's far easier for us to understand and get a grasp of the discussion relating to a particular definition that's in the context of the provisions in which it sits. So I don't know whether that assists you.
Oh, it does. It does. So yeah, so it means that I probably won't turn up tomorrow and I'll pop up as things arise. And I think that same thing comes up for me with the carbon forestry issue that Felicity has just said, well, that's sort of dropped away in terms of where Waitaki District Council, or was it? I don't know. But anyway, the issue dropped away. The broader issue around carbon forestry, but of course, I've offered up a response that's really a definitions-based response to the issue that's been raised by Ngātahuki, Murihiku and others around permanent forestry. So perhaps I leave that for another day.
A good example of that was what happened over the last 2 days, where in the context of the Mother Penoi chapter, we were looking at and considering in detail submissions, and that's as it should be. And there's the complexity really that arises out of the fact that someone from the Otago Regional Council has to deal with and address the submissions in relation to definitions in an overall sense, and that's what we're doing today and tomorrow as part of the introductory themes and definitions part. But in reality, if there are significant issues that arise out of definitions, it's far better that they're dealt with in context in the chapter that we're considering.
Apply. Yeah, that makes a lot of sense to me. So then, very briefly, on the matter of limit, Felicity was right. My paragraph does support her dropping off environmental from the front of limit. What is not in my evidence is why. And my why was simply that I didn't think environmental added anything given the broad definition in the RMA, and what's really important is that you're intentionally wanting to see a limit, and then we swing back to the interim frameworks and go, well, when and how are you going to identify that limit, and what are you doing in the meantime? I agree with Sandra on the fact that I'm really happy that we've got to the place that we've got with Fish and Game and Dock and the council on addressing the issue around trout and salmon habitats. So really satisfied there as well. A really important issue for us to see that resolved satisfactorily that way has been a really good outcome from the pre-hearing effort. I note I've got that section on effects management hierarchy. The opening from Alistair Logan having that discussion about avoid. There was a submission point from Ngātahuki Murihiku introducing, first avoiding in relation to Eco P3. What he expressed was my reading and understanding of first avoid, and certainly hopefully what you picked up from the Ngātahuki Murihiku submission and in my brief discussion and evidence is we were anticipating that as the first step in a hierarchy of responses, as opposed to first avoiding being, if you can't avoid, you don't get through the gate. So that's certainly how I was reading it. And I'm guessing that chapter 2 is going to get discussed this afternoon, because there's a couple of things there around the catlins, and you would have heard obviously from the kōrero yesterday, might have illuminated a bit more the significance of the catlins and why that's been requested in the description of the region. And so I guess that point will likely get settled this afternoon, although I haven't seen what Ms. Hawkins has said, but you probably won't see me this afternoon, no need, I imagine. Yeah, so that then leaves a question for me as to, I'm presuming that my rebuttal evidence around the hierarchy in the integrated management chapter, which relates to the Maori discussion that you've just had. We're sort of just wondering, do you want me to hold off to have that hierarchy discussion to the integrated management chapter next week, or pick up a bit of that today, because it relates so closely to that Maori discussion you were just having?
I think if you deal with that today.
Yeah, lovely. Okay. Yeah, so what I've noted is that if you relate it to the recalibration, it's the Māori coming to the fore is obviously recognition of mātauranga. It's also quite fully taking into account the iwi management plans that have been in place in the region for a long time now. So that's something that's part of your job as decision makers, to take into account those plans. And they've recorded, and the plans before them from Kaitahu recorded this same whakaaro over and over and over, which is that the importance of putting the Māori of the environment, natural environment, first is the way in which you live sustainably and live and keep the people healthy, keep the natural environment healthy, keeps the people healthy, and over successive generations. So that basic point in my rebuttal evidence was simply that the source of that hierarchy and prioritisation of protection and restoration of Māori is has a long-standing whakapapa in the region. It's not while it looks like the hierarchy in the MPSFM, its source is in fact mātauranga and the iwi management plans, and therefore it reflects the efforts to partner appropriately with Kaitahu and incorporate mātauranga, but also a recognition of the state of things and the job to be done, which I was referring to before, within the generation, and that it's a recognition of the community as a whole, that this is a time when investment in prioritisation of the natural environment, it's time for that to occur. In terms of the measuring aspect, we have had to grapple with this already down in Southland, and I was part of doing that. How do you understand how well you're doing at protecting and restoring Māori of the environment? And we've described a way to measure and monitor that in relation to fresh water, but the principles involved in doing that would equally apply in land and coastal environments. And some of those principles come back to how well do we understand what was here before, and what has been lost. By looking at that, it will help us understand what we could invest in to bring back health, whether it's soil or land cover, or I can't think off the top of my head of a coastal example right now, but maybe it's protecting an area from use to enable it to naturally heal. So the kind of rahui approach that Brendan was talking about with the power, but you can apply that kind of way of thinking to different resources. So I think that it's potentially not so hard to understand how to. It's not necessarily that. Well, certainly the way we did it in Southland was we weren't trying to measure Māori itself. We were understanding that to know how well you're doing at protecting and restoring Māori, you look at how well that place is providing for health and well-being of species and people, and that there are measures to use there, and you can bring environmental science and mātauranga together. It was challenging to do, but not ultimately. It was because it hadn't been done the way we were trying to do it. That meant it was a little bit slower, but within 6 months we were able to do that. And I don't see why we wouldn't be able to do something similar in relation to Māori of coast and lands as well as freshwater. So it's quite achievable, is what I would say. And also I think there's a misconception that when you prioritise protection and restoration of Māori, that somehow that's a prevention of use, and that was never the case. That was never the case under the Kaitahu resource management framework at all. It was always a relationship with use, always. So, which is why I was saying yesterday that there really is no incompatibility between this idea of prioritising protection and restoration of Māori and use of Māori land. They're perfectly compatible things. And that's so the way in which to approach that idea is actually to look towards the iwi management plans, and all through there you will see it's about the way in which we use things and how careful and sensitive we are about doing that. And then if we're in a place of deficit, which is was the reference in Evelyn's evidence, then we're adding back whilst we're using. And that's the utu reciprocity element. If we've taken more than we've given, then it's time to give back to restore balance. So yeah, kia ora. That's probably me. That's enough. It took more time than I thought. Sorry.
Just one quick, thanks, Maria, in terms of, right at the start of when you were responding to the conversations we were having with Sandra, probably around the economic, social wellbeing thing, you made a comment about investing in the natural environment will benefit social and economic wellbeing as well. And that probably kind of actually answered this, but just in your last statement. But it's a bit circular, that, isn't it? Because if we don't actually have social and economic wellbeing, we can't invest in the natural environment. So then it works together, doesn't it?
Correct. And that's where the interim, that's where the how do we know how fast we're going, and and what we're doing now to make sure that we get to where we need to get to by the end of a generation. That's the reason that you're pacing and being careful about that, is because there is that, the investment is going to come from existing economic activity, and it's
Reasonably important.
absolutely. It doesn't happen otherwise, does it?
Thank you.
You don't know, Maria, I don't really have too much to add, but I do want to acknowledge the point that you make about knowing what you had before. It's all very well to say, we want to restore and all that sort of stuff. And also to acknowledge the fact that, which I totally agree with, and that is that if we're talking about restoring something like Modi, the measures you do look at are the things that are in the environment that are going to move you back to what you knew was there before in that sense. So I acknowledge that totally. And that's always what I've believed anyway, but which is why I made my little flippant comment at the end there, where we have freshwater Modi measuring methodologies that I'm aware of. I'm not sure that I totally agree with any of them, but they're there. So, kia ora. Thank you.
Can I just respond to that in one way, Commissioner Kirikiri, which is just that there's often also a misconception that this idea of restoring Māori is restore to a pre-European state. That's not correct. When Kaitahu, well, certainly Ngāi Tahu Ki Murihiku are talking about this, we're talking about looking at that past state as a reference. It's a reference point, and it informs your actions to restore. So it's not the same as saying, bring it all back to a pre-European state, because we quite often see that, trotted out as a response to this, and it's actually not what's intended at all.
Thank you, thank you, Ms. Martin. And I have no questions that I need to ask, so we'll conclude this morning. And thank you for your attendance. And we'll break the morning tea now. It's 1/4 hour. Thank you.
Kia ora.
And I agree with her that feeling is good.
Oh, he's having a go.
Thanks for the time. It worked perfectly. No, I didn't. I deliberately held on to it. I'm going to. I just want to make sure that it worked myself.
Yeah.
I might try to get to I just want to come running back. So can you give me more of that tape? So, do you need it back straight away? Did it? Oh, okay then. All right. All right. Yeah, no, I did. I was going to bring back. I just. Yeah, that's. You got this hold on to it for the night to make sure that it.
No, that'll be fine.
Okay.
We've got the Director General Conservation.
Nakwe o te tumuaki o ona aikomihana I te panihira I Otago Rohe. I'm sorry, do I need to push something?
You need to push the button.
I'll start again. So Tanakwe o te tumuaki o na kaikomihana ki te panihira o Otago Rohe. Tēnā koutou o na kaikomihana. I do particularly want to acknowledge Commissioner Kirikiri for his previous membership of the New Zealand Conservation Authority for Atapai Taio o Aotearoa. And I also want to thank the panel for allowing me to attend today to present my opening submissions rather than yesterday when I had a standing engagement. I was not able to. So you have my legal submissions before you.
Actually, Penny, I don't, I'm just going to grab a copy if that's all right.
Yeah.
Yeah, it's B1 there. Oh, sorry.
Oh, sorry.
Did you discuss it? I gave you one, but I didn't. Oh, there it is. No. Thank you.
Well, the Director General's a submission and further submission on the proposed regional policy statement. And I do want to acknowledge on behalf of the Director General Kai Pahu, including Waitaha and Ngāti Manoe, as Tāna Whenua of the Otago region, and the Council prepared the proposed statement in partnership. So the first bit I want to talk to you about is the relevance of the Otago Conservation Management Strategy, and just to emphasise that the department has significant interests in the Otago region. So the department administers many areas and waters in the region, and to support this, it has the Otago Conservation Management Strategy 2016, which would have been approved during Commissioner Kirikiri's time on the Conservation Authority, and that was of course prepared under the Conservation Act 1987. So the Otago CMS is a strategy which the Council shall have regard to in preparing, and to the extent that it has a bearing on the resource management issues of the region. In passing, I do note that we do also have the Mount Aspiring National Park Management Plan that is quite specific to the park. I don't consider it's as relevant to this particular process. However, the CMS has 10 places identified for the purposes of integrated conservation management as requiring specific management direction. And perhaps of interest to the panel, this includes the marine, Te Pai o Aotearoa place, and the freshwater Waimaori place, which provide an overview for their management. And I draw to the panel's attention that the department administers many offshore islands and stacks in the marine Te Tai o Aotearoa place, which have high biodiversity values. And I'm also going to talk further below about the Southeast Marine Protection process and the Director General also has a particular interest in freshwater fisheries. The department's functions include preserving as far as practicable all Indigenous freshwater fisheries and to protect recreational freshwater fisheries and freshwater fish habitats, and advocating for the conservation of natural and historic resources generally. The Director General's specific powers include that she shall advocate the conservation of aquatic life and freshwater fisheries generally. Just in passing there, I note that there's a definition of fisheries and of natural and historic resources in the Conservation Act, and those differ to those in the Resource Management Act, which adopt the fisheries definition in the Fisheries Act. So just to remind you that we're not quite talking about the same thing. So in the Conservation Act context, the definition of fisheries is very much considering the fishery holistically. The Fisheries Act definition, it's thinking of a fishery more as a resource which is able to be fished, so a stock of fish which is able to be fished. Another way that the Director General demonstrates that so one way for the Director General to demonstrate she's meeting her direction to advocate for conservation of aquatic life and freshwater fisheries is, of course, being here today before this panel. But she has related roles, including to maintain fish passage, and that's into the Freshwater Fisheries Regulations 1983. I'm now going to move to talking about the High Court Declaration, and of course, in accordance with that, the freshwater planning instrument parts of the notified proposed statement are not being considered at this hearing, and that of course means that the specific parts of the Director General submission relating to those parts are also not before this panel. I do adopt the open submissions of my friend for the council, including acknowledging that having these dual processes is not ideal, and it does put the integrated management of the natural resources for the region at risk. The Director General submits that there will be connections and overlaps between the processes, and they should speak kōrero to each other. I agree. One way to do this is, as suggested by Mr. Logan for the council, that this process could be adjourned until the freshwater panel completes its process and makes its recommendations to the council. I've just noted here that the freshwater panel is not limited to making recommendations only within the scope of submissions made on the freshwater parts of the proposed statement, and that's in Schedule 1. They will, in my submission, have limited ability to make recommendations beyond the specific freshwater planning instrument parts of the proposed statement. And although I do consider that that will be related to freshwater, so it is limited to where there is an intersection and interaction with freshwater, but it is not limited to specifically those freshwater planning instrument parts. I also note that the freshwater panel is going to have the advantage of these hearings being underway, evidence being presented before you, even if you have not yet made any recommendations. In common with others, there are aspects of the Director General submissions relating more broadly to freshwater in the Otago region and which are clearly relevant in this process. And further down the track, we're going to be calling Dr. Maureen Rishasen to give expert freshwater evidence in support of the Director General submission. So the Director General does support the general intention of the proposed regional policy statement and the wish to integrate management of natural resources in Otago. Whilst the process may have been prompted by deficiencies, particularly for freshwater management, the proposed statement of course looks to all resources in the region and how best they can be managed holistically. The Director General considers the integrated management section is of fundamental importance to the proposed RPS. A primary concern for the Director General is the lack of integration for biodiversity, with these aspects addressed across several chapters. Another issue is the language of the proposed statement with inconsistencies across the document. And as an example, in her submission, the Director General looked to integrate management of biodiversity across the terrestrial, freshwater and coastal ecology realms, including by having significance criteria relating to each other. And that is addressed in the expert evidence for the Director General. I'm going to speak to that further at the relevant hearing. Just wanted to draw that to your attention now. Particularly in the coastal environment, the Southeast Marine Protection process in my submission is relevant. And it has been suggested there's a lack of information about this realm. The Director General disagrees with that and points to the work underlying the Southeast Marine Protection process, which began back in 2014. This process is ongoing. Following a further round of public consultation in 2020, the Minister of Conservation and the Minister of Oceans and Fisheries are to make final decisions in relation to various proposed marine protected areas. It is anticipated the said process will be concluded this year, and that will result in the creation of a new suite of protected marine areas in the coastal Otago marine area, as well as outside of this region. So that is another potential danger which the hearing panel need to be aware of, and it might be that that will require further legal submissions at that point. The last matter I particularly wanted to address in my opening legal submissions is the relevance of the exposure draft of the National Policy Statement for Indigenous Biodiversity. And again, I refer back to my friend's opening legal submissions. I do agree that until the gazettal of the draft NPSIB, Council is not required to act in accordance with it. I disagree it is of no relevance, and the panel would be wrong to recommend amendments to the proposed RPS based on the draft NPSIB. Perhaps if I rephrase that, in my view, the panel should consider the draft NPSIB. I note the purpose of releasing the exposure draft NPSIB was to test the workability of provisions with key groups. It already incorporated feedback from previous public consultation and hui held in 2019 and 2020. In my submission, that advice indicates the process for the draft NPSIB is well underway, and the policy direction is largely settled, clear, and it is consistent with the most recent amendments to the NPSIB. I consider the panel would be mistaken not to consider it. I note in the timing provisions of draft NPSIB, there is an expectation in local authorities, including the council, will give effect to it as soon as reasonably practicable. It also provides that where a document may already give effect to it, changes to wording and terminology merely for consistency will not be required, although it is for the council to consider that the proposed document does give effect to the draft NPSIB. I submit there is value in the hearing panel considering the draft, and within the scope of submissions, including that of the Director General, considering whether it could adopt and recommend wording which could potentially give effect to this document. So just some final comments. These submissions are made in opening. They are intended to draw general matters to your attention at the start of these hearing processes. Council will present further submissions for the Director General on specific topics as evidence is called and if appropriate. And today, of course, I have with me Mr. Murray Brass, the Director General's expert planning witness. He is here particularly to answer any questions you may have in respect of his evidence on the introduction and general rules, and also the mana whenua and resource management issues of interest to you. Thank you.
Referring to your paragraph 11 and button, just referring to your paragraph 11, and this is something that we've had discussion that I know you referred to the advice from Mr. Logan. Yeah, I'm just sort of interested in if you've got any advice for us on the sort of procedural way that this could happen. I mean, you've suggested here that one process that we could adjourn until the freshwater panel completes its process, but how in your mind would be the ideal way to make sure that those two processes do mesh together?
It is really difficult, and in that particular paragraph, I am adopting or noting Mr. Logan's suggestion. I was, again, because I was having a look at Schedule 1, I was having a look at timing and how things work together, and I'm conscious that, you know, ideally this process is to be completed by, I think it's September this year. There is perhaps a little more flexibility around this process, and I suppose that's why the proposal or the suggestion is that it would be this panel that perhaps would look to potentially adjourn as opposed to the freshwater panel, which really does have quite an imperative to complete its processes within its 2-year period. I'm currently counsel for the Director General in the Southland Water and Land Plan process, which has been ongoing for many years, and where we have just had the 5th interim decision of the Environment Court, where the court has, perhaps a little bit frustratingly, but still, but the court has again considered evidence before it and submissions, and then come back to counsel and the parties and said essentially, here is something, some things have been finally decided, but other things are a bit loose still. They still need some testing. We might want to have some further evidence and submissions about that. The difficulty that I have is I am just not clear in my head whether it is open to this panel to do some kind of interim recommendations or not. And I think that might actually be something that needs to be resolved between the panel and the council as to whether or not that is a process which is open to this panel. Because certainly if the panel was able to do some kind of interim recommendations, but subject to whatever might come out of the freshwater panel process, that would help to move things along. And it would also assist this panel, because obviously it is far better for you to make decisions and recommendations when the evidence is fresh in your minds. It is not helpful to have to pause, put yourselves on hold, and then sort of sometime later come back and have to restart and do all that thinking again. So I'm not sure that I have a particular solution for you, but if that could be accommodated in some way, that would be the best way that I could see of trying to have the two processes together.
Yeah, thank you. Does anyone else have anything you want to ask on that before I move on to another question?
I don't know, you just-
I'll box on. Look, and this is a question I was going to, that I'm interested in Mr. Brass's comments on as well. In his evidence, I believe he stated around consideration of the MPS for Indigenous biodiversity that we should be considering it as sort of, I suppose, best practice for integrated management of biodiversity. And I suppose that sort of, got me thinking about, the extent to which we can and should be considering the exposure draft. And I know from sort of, previous involvement in developing policy direction that there's always a lot of compromise that goes on. I know that this process has been underway for a very long time. To what extent, I suppose, I'm thinking, can we actually consider it best practice? Because I mean, to my mind, what's in that document may not be best practice. We can certainly go beyond that if we choose to, even once it actually comes out. Should we be considering the provisions of that document without recourse to some technical evidence that is backing up what those provisions are trying to achieve?
So I would hope that the Director General's technical evidence will assist you with that, and in particular that of Ms. Neely, who I think certainly assists with some of that, and also Mr. McKinley, Dr. Schultz, and Dr. Richardson. So there is that technical evidence, which is, I think, probably going to come in the ecology and land and freshwater sections of the hearing. This is actually thinking about what's in the NPSIB, not necessarily as a policy document, but as a source document. And that's perhaps the way in which Mr. Brass's evidence approaches it, is that it's actually looking at it in that way, in terms of, so the department is the lead for the New Zealand good government principles of biodiversity offsetting and compensation. There's a later document which I think is prepared in part by Local Government New Zealand, which also deals with principles of biodiversity and offsetting. So those are an example of two documents, which each of them is now some time ago, in which there has been progress made from, and that progress is, as I understand it, reflected in the MPSIB. And that's the kind of way in which, in my view, you certainly can consider it. There's also I guess, thinking about this in terms of the National Policy Statement for Freshwater Management and we see the fundamental concept and principle of the mana o te wai. There's a related concept which is in the MPSIB and te mana o te pao. I'm not saying it's the same because it's not, and I'm not saying that it would be implemented in the same way because I don't think it is, but it's just something which is there, something which is relevant, and something which, in my view, my opinion, this panel should be cognizant of and thinking about when you are considering this process and what your outcome in terms of your recommendations.
No, thank you, that's helpful, and I know we've had some advice around this topic in this course too, which has been useful. Thank you.
I've really just got two timing issues that I wanted to have a response from you on. One in relation to your paragraph 1920. What is the potential timing?
So my understanding from this is internally is that the expectation is that a paper will go, or papers, because there's briefings to obviously both ministers, that briefings are expected to go to ministers soonish, and certainly within the first half of this idea, and ideally decisions would be made prior to the election, which has now been announced for October. And that's as much as anything else because the process has been ongoing for such a long time. We need to bring this to a close.
What's the, just remind me of the convention for the election shadow, no decisions, period where ministers essentially abide by a convention that they just don't make.
Yes, and
significant decisions.
so ideally, I think that period is 4 months. What I would point out is that this particular process actually began under the national-led government through to 2017. So I don't expect it to be as contentious as potentially some other process which would be subject to that convention.
Right. And the other timing issue really was again the MPSIB, because I mean, as I understand it, it's been so many years in gestation already. Is it realistically on the calendar for this year?
It is certainly realistically on the calendar for this year. There were a couple of factors that meant that it was not dealt with by December, which was the expectation last year. So realistically, it is on the calendar. And, whilst I anticipate there will be some changes in the current government ministerial portfolios, I can't see Minister Parker giving, and Minister Shaw for that matter. Well, actually, because it's Minister Shaw who is driving the MPSIB and his portfolio won't change. So it's certainly a priority, as I understand.
Thank you, and thank you for your thoughts. Yankees Sullivan's already covered with you the other issue that I wanted to just have your thoughts on in relation to your observation for paragraph 11, because there is an issue about how we speak to another panel without making decisions, and how we avoid the trigger of appeals, or how the council the recommendations or not. And just our ability to take into account the natural justice viewpoint, our ability to take into account views that haven't had an opportunity to be addressed or challenged by submitters. So if anything brilliant occurs to you during the course of the hearings, don't hesitate to bring it forward. All right.
Indeed, I will. Thank you.
Thank you. Right.
Mr. Rouse.
Okay.
I'm a senior RMA panel, Department of Conservation. In terms of today, I'm really just here to answer questions. There are a couple of matters where, with your leave, I may make some additional comments. I would note that my evidence included some background and general statutory considerations and very brief comments on mana whenua. And so I'm open to answering questions on any of those matters, not just what's directly in front of us today. There are probably 3 areas where I'd suggest just making some additional comments. I'm open to your direction as to whether you want to take questions first, and then I can fill in with anything that's not covered.
Preferable if you address this.
So they relate to provision for specific industries, the MBSIB, and also just working across the 2 processes. So in terms of provision for specific industries, and there have been quite a number that have put their hand up through this process. In my view, it is certainly open to the panel to include either explanatory text or provisions that relate to specific industries. But in doing so, that needs to be driven by resource management issues. I have some concern that we're in a situation where some industries have put their hand up through this process. Some industries I'm moderately familiar with, education in Otago, have a very significant generator of employment and income, and obviously education underpins sort of everything that follows in terms of the economy. They haven't put their hand up here. So to avoid a situation where some things are potentially given extra consideration through the RPS, I would just encourage the panel to make sure that if you do that, there are clear resource management reasons for doing so, not simply who's raised that through the process. I do think there was specific discussion about mining and aggregates. My clear preference would be, well, no, firstly, I do accept that they have constraints and that there will likely be a need for some provisions to provide exemptions, exclusions, alternative pathways, and recognition of that. My preference, though, would be for that to be done at the chapter or provision level, where you can specifically say, well, look, for Indigenous biodiversity, for example, offsetting the compensation may provide an alternative pathway, but for air discharges or transportation effects, you may take a different approach. So to be able to build that nuance in terms of how you respond to those industries, my preference would be that that's dealt with at that lower level rather than providing like sort of a generic exemption or special provision. I just think that then allows the provisions to more accurately reflect the different issues that are involved. In terms of the MPSIB, firstly, just note, no, it doesn't have legal effect. And so the panel has to make its own decision. You're not simply directed in terms of what to do there. But there is evidence from a number of certainly the Director General's expert witnesses and others, which does support, in some cases, the general approach, in some cases, the specific wording. So in my view, we're certainly open to the panel to essentially align with the MPSIB as a decision that you make yourselves. And that's a matter then for the evidence. I would also note, though, that all else being equal, there is potentially an efficiency gain and aligning with the MPSIB, simply in minimising the potential for having to go through future processes to make changes to the RPS to align. So if you're able to align now within the scope of submissions and evidence that's in front of you, I consider that it would be more efficient in the long run to do so. And my only other comment, and I certainly don't have a solution in terms of freshwater and non-freshwater processes. I would just suggest that something that can be helpful while you can't make decisions through this process on the freshwater. There is certainly the ability in any decision or interim decisions to provide explanation and signposts. So the sorts of things I'm thinking there would be that in this decision adopted this approach to a particular definition. For that definition to work within the freshwater domain, we understand that that would need to X, Y, Z. So provide those leads to assist the decision making and the other process. So that's the matters that I had, the particular comments that have come out of proceedings so far, and apart from that, I'm happy to take any questions.
Thank you, Mr. Price.
Yeah, thank you, Mr. Brass, that's helpful. Just you commented in relation to the NPSIB encouraging us to align where possible based on the submissions and evidence that's before us. Have you done an exercise of sort of looking at whether we do have that scope? Do you think the scope within the Director General's submissions to align with the content? I'm sort of aware that the exposure draft has come out slightly later in the piece.
Yes, certainly, and probably key elements in terms of the Director General's witnesses would be around the effects management hierarchy, provisions for offsetting and compensation, and significance criteria. So in those cases, there is quite specific evidence from the Director General's witnesses.
Great, thanks, Mr. Ross.
Morning, Murray.
Mr. Hewitt,
And you did ask for this.
you can ask me about Solna, right?
Yeah. But just for the panel's information, you may read in Mr. Brass's qualifications and experience that he was the manager of regulatory services and planning in Cloaker District. So you're in quite a unique position, I guess, and I understand you followed our discussions around Silner and the provision for public like and that sort of stuff. So I'm just wondering, actually, I'm just going to give you a carte blanche. Do you have any, because the concern raised, well, which I was raising, having dealt with this issue probably for 30 odd years, is the other parties that get involved, and it used to be DOC, and DOC sort of got quiet on that. At this stage, although if we apply the integrated management process and all the other policies kick into that, when the lower order document starts to deal with the use of those lands, I'm just interested in your view around that process. But you may have been hearing Paul Freeland was here yesterday around the DCC's concerns around that. So I'm just wondering from a DOC perspective now, and also with your old hat on, if you had any comment around that and how it might work in reality.
So I guess first, just to be clear, I'm not in a position to speak for the Department of Director General. I don't know if any but that comes up. I would note though that is quite some time ago. There's certainly been significant changes within the department. There have been legal decisions such as NITI, which have forced changes within the department as well. So I certainly would not presume that the department's views or position of 20 odd years ago applies now. In terms of my personal opinion as a planning witness, the first point I would make is, and there's quite a bit of discussion from what I was able to follow online around the various provisions of section 6, 7 and 8 that relate to Māori lands, cultural interests, te tiriti. If those provisions are there, or because those provisions are there, you have to assume that they're expected to bear some weight and decision to have outcomes that are different to what would occur if they simply weren't there. So from that point of view, I do think it is entirely reasonable to come to a point where you say that Papakaika lands may be treated differently to privately owned land generally, and therefore could have different provisions that apply to them. There was the issue raised from what I followed yesterday about that being triggered simply by a change of ownership. And I would have concerns if essentially effectively the planning rules that applied to a property were triggered, were changed simply because it was a different owner. But I don't think that's a barrier to recognising that need. It's more about what's the mechanism or machinery. And of course, the RPS is not actually the place that sets that mechanism and machinery for what may be plan changes to district plans, for example. So in summary, I think it is entirely both open and appropriate to provide for particular uses of Papakaika land that are different to other land.
I guess the issue that's been raised though, is around primacy, and this is directly relevant to DOC, because we know those Silner lands, there is section 6 matter probably applies there. Whether that's appropriate and whether that would be an issue, I guess. Is to somehow a document could actually say, well, section 6E sits above the other ones in this particular circumstance.
Yeah. And the current legislation is a lot of help. I would have concern about simply extracting one element of section 6 and saying it has absolute primacy. I would be much more comfortable with, if you like, sort of seeing it as a weighting. And I think, you know, in the same way as if a site has significant Indigenous biodiversity values, that's then considered, you know, what are the values, what is the level of significance? In the same way, I think it's a weighting or an evaluative exercise, but I think it certainly does make it open to say, well, look, we would allow this to happen in these circumstances, which would not apply. You know, there's a dividing line, if you like, compared to this general private freehold land.
And the Silner lands, I think, are slightly different to some of the native reserves that have been created, because I can't, any shape of head, you may, nodding, you may recall the phrase that social and economic well-being, and it wasn't necessarily linked to ancestral uses.
The whole point of the Silner lands is actually that they are lands which were granted or reserved for landless natives. That's South Island Landless Natives Act. So that's what the Silner lands are. So there isn't a whakapapa ancestral tie back to those particular lands. Yeah. And there are areas of Silner land which are all around Vanuatu. And so that I would not equate Silner lands with Papakaika lands necessarily. They are intended to essentially as a resource, perhaps in quite a specific way, because the purpose of that legislation, and I'm having to remember it's a wee while since I looked at it, but I think the Act is 1906, and the intention was that those peoples had been so disadvantaged that there was a need to provide some land which they would then be able to earn a living from. That was the purpose of the Silner legislation.
That is the crux of the submissions of people that own that land, is that it was given for that purpose, but
yes.
we had but because when it was given in 1906, no one really cared about that, and it was a piece of rubbish land that European farmers didn't want.
It was certainly not high quality.
Yeah.
Put it that way.
I would have thought though within, particularly say, Toku and further down in the main part of the Catlins, there will be ancestral connections, particularly in those estuaries and with a lot of Mahikakai.
I would agree with you. I anticipate that is the case. I'm cognizant that there is the outstanding coastal and marine areas processes which are particularly down in the Catlins, and I suspect, I don't know, that they are also connected to the whenua, and that there's probably an overall sense. I really can't help you any further than that.
Thank you. I was just getting your sense of how that may play out. Sounds like it'll play out like it always plays out.
It will continue to be difficult.
Yes.
Sure, Mr. Bryce. Whilst you say you agree with the Section 42 report on mana whenua issues, and you don't have any particular worries in there, but I would be interested though in hearing your views on the issues that you have looked at under that chapter, the mana whenua stuff.
I guess in summary and I don't claim to be the expert on mana whenua issues. You've heard from the experts over the last couple of days, and I've certainly enjoyed what I've been able to either see in person or dial in for. As a general perspective, I support the specific provision for mana whenua issues within the RPS. I'm generally comfortable with what's proposed there. It's quite clear from the discussions over the last few days that that is not yet, if you like, sort of finally settled, and there are still matters of debate and further discussion. And I guess just to be clear, while I generally support that 42A outcomes, I'm certainly have no objection and would expect that there will be further iterations and changes that come out of that process. So I'm not locked into, if you like, 42A wording.
There was a fair amount of mention has been made already about Te Mana o Te Wai. Very little has come out about Te Mana o Te Taiao, which you raised in your primary evidence. And I wonder if you wouldn't mind also then just telling us a bit more about your views on, I mean, you say, whilst it doesn't have the kind of legal standing that you might expect, but your recommendation is that we should pay some attention to it in our deliberations. Can you just talk to us a bit about that?
So this is referring specifically to Mana o Te Taiao, New Zealand, AFRO, New Zealand Biodiversity Strategy 2020, and the implementation plan which followed a year later. So yes, they are not documents which have direct statutory weight under the Resource Management Act. And I guess I would just note that lack of different legislation talking to each other is one of the key reasons why we're looking at a major reform in terms of how we deal with resource management. While it doesn't have statutory effect, it is a matter that can be had regard to. It is a very high level, it's a government level document. It sets expectations for a wide range of organisations and agencies, which include the Department of Conservation and regional councils and territorial authorities. So from that point of view, I think it is a relevant document to understanding what the roles and functions of regional councils and district councils, city councils are. It is set some quite clear expectations in terms of biodiversity. I think the RPS and plans that follow from it are clearly expected to be part of how those things are implemented. So I would see two things. One is it does give further weight from outside the direct RMA documentation to the importance of biodiversity and the need for it to be addressed. And I would also encourage, and again, I think there's an efficiency argument that to the extent that the RPS can be consistent and fit in with that framework, that is likely to be more efficient and more effective in the long term.
Thank you very much.
Just going back to those salt lands, my understanding is that particularly the northern iwi were intended to be housed of all places down in Stewart Island and on those salt lands on the east coast of Otago, and that in itself was seen by the Taui inquiry held to be a treaty breach in terms of their expectations, but in the tribunal earlier in the Ngātahi reported held that it was a treaty breach of utilising Ngātahi lands for an old whenua purpose, but that none of that removes the ancestral links that Ngātahi have with those areas. And the thrust of what we having put to us is that they have such a tiny percentage of their previous ancestral lands now available to them by way of settlement that's come back to them, that these broader interpretations of Māori land and Papakayaka joined together should be enabling. And that then has led to the further consideration by them that it shouldn't only be for residential purposes and housing purposes, because how on earth can you live in those more remote areas unless you have the opportunity for economic activity? And it's that aspect which then usually gives rise to either landscape, seascape impacts, discharge to air, discharge to land, whatever it might be that flows from those activities that is difficult. If I put it, try and search for a neutral word. I'm interested, Mr. Rice, in particular, on how you feel about that aspect of the recommended Papakayaka definition that is being recommended to us by the Section 42A report, i.e. really economic activities as well, needing to be provided for in those settings, a large number of which appear to be on the coastline.
I guess as a first point, and this is really that issue that in a way these are replacement lands for people who were landless. And I think that even if you then saw that as not having therefore those long-term ancestral lands ahikai, the requirement in terms of that Tatariti under Section 8 is clearly very directly relevant to those lands and how they've come about. But I would also say that, and I'm cautious here about speaking for other people, but in my experience from what I've seen, I feel that a lot of people who now have those lands do have, over the time, have developed connections. It has gone through a number of generations. So I certainly would not consider that that's, if you like, no different to any freehold land that they may own. I think there is now a historical, a whakapapa, a multi-generational connection with those lands, which needs to be considered, and again takes them out of just being treated as the ordinary, there is something particular there. And in terms of commercial activity, I think my view is similar to Papakaika. I don't think it should be an absolute, you could ignore everything else, get it a jail-free card. But I do think that there's some significant weight that needs to be applied. And I'll be certainly very comfortable with definitions and policies that direct users of the RPS to apply some weight to those connections that they have with those lands.
Thank you, and that's a very helpful response. I think that's all that I have. Yeah, covered that well. Thank you very much.
Thank you, we will be back. I don't think we've met this week, but we'll be back in the next week.
Thank you.
Thank you.
We have listed this Dunedin City Council again, Mr. Prince. Not sure whether that's anticipated or not.
It's going to be AVL, but he's not currently online.
I can contact them. I don't think he was before
Sorry, could you speak?
I can contact him. I'm not sure he expected to be needing to be available right at this instant. He may be available in a short time.
Is it easier for you if we specify a time immediately after we have a lunch break?
That would be great. Yeah.
Right, well, look, I think that Oceania Gold are obviously will take us some time. So is Benjamin Murray present?
Yep.
You're right. Look, sorry, Mr. Murray, if you come forward, but Mr. Murray, how long are you anticipating that you'll take?
Not very long.
Right. I think if we work safely on the basis that we ask Mr. Prince to be available at say 1:45.
That sounds good. I don't visit you with the lines because evidence is.
Okay. Thank you. Thank you. Thank you, Mr. Murray.
I've also
Sorry,
got my,
Mr. Chair, I'm Stephen Christensen representing Oceania Gold. I sort of make the panel aware.
Didn't recognise you, Mr. Christensen.
No, it's been a few years.
Your hair's gone right in the meantime.
Thank you very much.
So much.
So I'm ready to go with my submissions at your pleasure. I'm only proposing that I'm going to present some legal submissions today, and no witnesses will give evidence. I'm just going to do a bit of scene setting. So I just thought I'd add that into your thoughts in terms of when you timetable things.
All right. Well,
I've got 17 pages of submissions to read through.
right. Well, look, on the basis of what we've been talking about, you're welcome to say that you equally you wouldn't be expected to be on probably before 2 o'clock in that case.
Thank you.
All right. Thank you. Thanks, Mr. Murray.
thank you, Tēnā koutou. I'm also joined by my colleague Elaine Desfountain. He's the plant manager at our site in Makadau, which is just the name from Palmerston. So I'm here from Greymont. We're a lime and limestone company. I'd like to point out up front, I'm not a planner, but I do know a bit about our industry. I know you've got our submission and worked through that, but I thought I'd just reiterate a few points. So firstly, the products that we make, lime and limestone products, are really important for lots of different parts of our society and economy. And we saw that probably most clearly during the pandemic. So we were asked to continue to operate right through the 4 lockdowns, supplying places like drinking water facilities, treating water pollution, supplying OG fibre for pulp and paper manufacturing, things like that. But we also supply agricultural sector, sweetening soil for growing crops, grass, milk and meat processing plants, mineral extraction, and as well as construction. So the products are really important. We're not a very large site, but those products are relied on quite extensively. The other point is we're a mineral extraction operation, so I think it's points been raised before that we have to be located where the minerals are, can't move. And we have certain challenges at that site in Makadao. So, for instance, our quarry is on top of a hill, which at various times has been proposed as having high landscape value. So we have to manage that effect. And our processing plant in the bottom of the valley is located within a historic heritage site. So it's actually a lime archaeological site. So there's been lime processing at that plant for well over 100 years. So in both instances, we've been able to manage the effects successfully, and we expect to be able to continue to do so. But really, I think that just about submissions is that we have a policy in the RPS that allows for those effects to be managed rather than necessarily needing to be avoided. So that's really the points I wanted to make, and we're just here to answer any questions that you might have.
Thank you very much, Mr. Buckley.
Yeah, thank you very much. Probably just one question from me. I mean, we've heard evidence primarily from Ms. McIntyre for Kaitahu at this stage. No doubt we'll be hearing more around whether certain industries should be emphasised through the RPS. And I suppose the view that we heard from her, and I'm not sure if you were here for her statements or not, but that we really need to be focusing on effects rather than focusing on specific industries. And I know we were just hearing from Mr. Brass saying education is not represented here, and that's again another major big industry in Otago. I mean, what's your response to that? I mean, I suppose what we're hearing is deal with specific industries within the specific chapters around the effects that we would see on those parts of the environment from those specific industries, rather than having sort of standalone provisions which provide for or acknowledge those industries. Have you got a response to that?
Well, firstly, certainly from my perspective, we're certainly not trying to avoid having to address or manage effects. So that's part of what we expect to do and have done. The concern is really that policy is there that requires us to avoid any effects. In some instances, it might not be possible to completely avoid effects. As far as kind of the structure of the RPS goes, I'm not really in a position to provide. I think our first submission on the RPS talked about having a general policy that dealt with mineral extraction specifically, and then it's evolved since then. So yeah, I'm not sure that I can give specific answer to how it should be structured.
So you've indicated you've got your quarries on top of the hill, so you've got landscape effects to deal with up there, no doubt amongst other things. I presume you've got specific zoning in the district plan at the moment, which is reasonably enabling.
It's currently zoned as rural scenic, I think, but the Waitaki district plan is being reviewed at the moment. So proposed draft, it's called the draft district plan, I think, is proposed feature. The other effects from the plant are similar to processing plants, air discharge, water usage. And they're going to be needing to apply for consents later in the year to look at overburden replacement.
Nothing from me, just to give you a little bit of comfort. I do know where your plant is, having been involved in some stuff next door. And you currently are a Senate resource area, isn't it? So that is proposed to change, saying in the Waitaki. Is it your particular site, or is it the hills behind the bush range?
So I think I thought it was rural scenic as the current zoning, and then the I think they call it the Blue Mountain Ridge is the proposal to put it that would be an outstanding natural feature on that ridge line. Which
You guys, your plant sort of sits in front of that, doesn't it?
plant sits down in the valley, so you can't actually see the plant.
Yeah.
Road, you have to drive right up. Okay, to see that.
Thank you.
What did you say the plant was on a historic site?
Yes, so it's I'll have to get what I understand, the whole lime processing plant is or site is listed as an archaeological site, but there's sort of an exclusion zone for the current modern plant in the middle of that site. But in some instances, our structures that we still use go right up to the edge of some of those old structures. So it's quite a congested site, and we expect that as we develop site, have to upgrade. For instance, things that we're looking at would include switching from our fuel usage. Currently we use hot coal to get the high temperatures that we need for lime burning. As we switch to some other fuel, that will need to make changes that might have some effect on that heritage. So
I have no idea where the site is, so excuse my next question, but is it near a built-up area, or is it?
Our nearest neighbour.
Nearest neighbour is probably 2 kilometres away.
Sorry?
2K away.
Okay.
Yeah. So it's pretty secluded. There's no direct neighbour per se. So,
The reason I asked the question is that Commissioner Sullivan referred to Sandra McDonald's evidence early on. Part of her evidence and some of the other conversations that have been had here around, I guess, just reaction to mining and all that sort of stuff. And it did appear to me to ask the question as to how close the nearest, perhaps marae or any other Māori village might be to your quarry.
The irony is that Ngāi Forestry operate right beside it.
Well, there's that as well. That kind of stuff. Yeah.
yeah, my understanding, the closest marae is in Karatani.
And that would be about what?
50, 60K away, maybe more.
Yeah. Yeah. See, just my ignorance.
No.
Okay, that's cool. Thank you.
So my look at the map when I was at Melbourne reading your evidence, I couldn't get a clear picture as to which catchment necessarily any discharges would run into. Is it a couple of catchments?
I think eventually it runs into the
So we're situated beside a creek. It's an unnamed tributary to the Shed River. So the creek has not got a name.
Right.
Yeah, that's the only.
But essentially, if I'm looking at the right location, you're up right up the end of a road that curls up onto the Blue Mountain Range. Is that right?
Pretty much. Yeah.
And okay. So in essence, the effects that you are trying to manage, I imagine from my knowledge of lime quarries, which seem to generate a huge amount of problems up in Marlborough, but because the transport problem basically runs through much more densely occupied areas than you were describing. But I take it it's essentially in terms of the extraction activity, is there a noise aspect and dust creation aspect?
There will be, but in terms of
Transitory noise, or in other words, use of explosives and the like?
yeah, and we're not currently extracting all the time, but with our nearest neighbours being 2 kilometres away, doubt that they actually even hear anything.
Right. So it's not an issue that you've had to deal with.
I don't believe so.
No, and we do proactively warn our neighbours that there's going to be a blast.
Right.
But I've never come across anyone coming to me going, "We heard that," or yeah. And a blast is typically every 6 to 8 months.
How do you do that? You just do it on the radio, you ring them up or
On the phone.
the phone? Okay.
So there's so similarly again because of location, there's dust not a major issue for you. Traffic effects.
No, again, it's not a large site, so it's not.
So in Southland and Otago generally, what other lime plant stuff are there?
There's quite a number around on.
Yeah, we're the only quicklime manufacturer in the South Island, so with a rotary kiln. But there are other sites in the Otago Southland area that manufacture ag lime, which does not go through a burning process. It's just raw limestone crushed up and used in agriculture.
And for the industrial uses that you refer to in paragraph 11 of your evidence, Mr. Murray, that's involving what, that kiln type process?
Yeah, generally it's quicklime, so it's being calcined, and then some of it's also hydrated as well. So
what sort of, would you get liquid discharge coming from those sort of processes?
we recycle the water used, so there's actually no water discharge from your site. The main discharge from that plant would be air discharge stack.
Look, thank you very much, and thank you for both coming along and informing us. And it takes time out of your busy days to do so. So thank you very much for the effort you put in. Thank you. We'll break now for lunch, and we'll reconvene at that 1:45 time.
Wow.
Yes.
Sometimes you do that in the chapter. Chapter.
Got it, Mr. Prince. Yeah, are you hearing us?
Kia ora.
We're in your hands. Thank you.
Thank you. Firstly, my apologies. I was apparently talking over you yesterday and it was not something I meant to do. And I can hear you today loud and clear. So I hope just sort of wave something at me if I do it again, please. I'll just increase that.
We can hear you well today, and we've received that summary of evidence. It's just been circulated, so we haven't read that.
Sorry, you have not read that, or so.
Right.
So you would. Is it okay if I just read through it then?
Yes, absolutely.
Thank you. I've been through my pepeha and introduced myself to tangata whenua, so I'll skip that bit, and you know who I am and that I have now caught up with the Code of Conduct for Expert Witnesses 2023. So I move on to my scope of my statement. If it's, I understand you're addressing two parts this afternoon separately. If it's okay with you, I'll combine them. Then you won't have to put up with me again. So, so in this section of evidence, I address the usability of the proposed RPS, which was section 5 of my evidence. Use of the term avoid and the language used, which was section 6 of my primary evidence, and the cross-boundary and interpretation matters, which was section 7. Now, my section 4 of the statement, I touched upon the usability of the proposed regional policy statement yesterday, and just would like to reiterate that it is important that it is made as usable as possible. And we went through the options I provided yesterday. The aim, as we discussed, is to cross-reference the issues, objectives, and policies so that there's a clear thread that the user can follow when they're working with a specific issue. Probably the main part of the statement today is around language and the use of the term avoid. It was discussed at length in the submissions from Mr. Garbutt. And as I stated in my primary evidence, language in a policy statement or plan is important, and I'd prefer the use of plain English versions where possible. As Mr. Garbutt has submitted in his opening, the word avoid, since the Supreme Court's King Salmon decision, has taken on a very directive meaning to the effect that unless there is a qualifier, for example, except or unless, then the effect referenced must be avoided. This places some significant strains on the lower order planning documents where there may be unintended consequences resulting from the need to avoid an outcome or an effect. And the language used of avoid as a first priority or to generally avoid is unhelpful in enabling alternative and potentially better approaches to be made in undertaking an activity. I have addressed 3 policies in particular in my primary evidence. They were AIR P4, EIT N P5, EN P5, and EIT TRAN P21. and suggested alternative wording that would enable the lower order documents flexibility in addressing the issues identified in the policies. Section 42A report has addressed a number of areas where directive language is used, but there may be other policies that should also be addressed. I would suggest that a review of the use of directive language through the whole of the document is undertaken and based on the DCC general submission. So it's not out of scope, that's what I'm meaning there. So that a more considered and enabling approach can be implemented through the other regional and district plans. As I stated yesterday and in my previous evidence, in my opinion, policy Air P4 may be deleted as it is in itself subject to the higher order NES on air quality. And I discussed that yesterday. For completeness, I provide my suggested wording to policies EIT-EN-P5 and EIT-TRAN-P21 in my statement. But I won't read those, I'll move on. Next section is regarding part 1, the cross-boundary and interpretation matters. The main points I make in this section of my primary evidence are the use of language that is consistent with the higher order documents, in the specific case of the National Policy Statement for Freshwater and the inclusion of regional landfills as regionally significant infrastructure. In particular, I requested that waterways is replaced throughout the RPS by the defined terms water body or bodies to maintain consistency with the NPS. And with regard to regional landfills, my view is that they remain the most effective and efficient means of managing municipal solid waste for the foreseeable future. A well-managed landfill is subject to consent conditions that control its operation and provide for the collection and treatment of leachate and air discharges. The alternative potentially is fly tipping and illegal dumping. And that is why, in my opinion, regional landfills are regionally significant infrastructure, and they should be included as such in the definition in the regional policy statement. And I include that. And as a consequential change, you may like to consider that municipal solid waste should be defined. And I have suggested a definition there. That's the end of my statement. I'm open to your questions.
Thank you, Mr. Friends. Bianca.
Yeah, thank you, Mr. Prince. Just one question. I suspect when we come to hear the air chapter, we'll be revisiting the issue of P4 and I would think how the ES air quality sort of interacts with the provisions in that chapter as well. But as at paragraph 5.3, I suppose you're referencing that the language used, you're saying there is unhelpful in enabling alternatively potentially better approaches. And that's something I've certainly seen in plans where somebody comes up with something that actually is much better than the status quo and the policies can be can prevent that. But if you then go on to talk about ERP4, and I see that really is dealing more with solely with effects rather than activities. Would you agree with that? I'm just struggling to reconcile your statement in paragraph 5.3 with
5.4. Yes, I would agree with that. I've tried to compress a number of things into a few paragraphs for the statement, and Air P4 is part of that. The key ones in this statement, and I dealt with Air P4 yesterday, is EN P5 and TRAN P21 for this statement.
Yeah, and I do note there that they do deal more with activities than specifically effects only. So
yes,
yeah, take your point on that. Thank you.
Thank you. Just on the landfill issue, I think my understanding in the South Island is probably only 2 class 1 landfills here, one down in Brown's Southland and one north of Christchurch. I'm just wondering how they are dealt with it, and you may not know, but how the original policy statements deal with those particular, because there are other landfills that sit below them. Just wonder how are they addressed in those RPSs, and is there a hierarchy?
I don't know is the short answer. I apologise for that. It may be something that the regional council planners may be able to assist with.
Sorry, I'm assuming that
I
this was going to be a class 1 landfill if the appeal is successful.
If it was a regionally significant landfill, it probably would be. I'm not familiar with the distinction between class 1 and others. I would suggest that there may be more territorially located and operated landfills that are less than class 1. I know Tauranga City sends all its landfill material to Horsham Downs, which is a class 1.
Okay, thank you.
Neither Roe, Kirikiri, nor myself have any further questions, Mr. Prince. So thank you for making yourself available today. And we'll obviously be seeing you again.
Yes, in February. Thank you very much, commissioners. Thank you. Bye.
Good afternoon, Commissioners, and thank you for the opportunity to talk. My name is Stephen Brosnitson. I'm a barrister representing Oceana Gold in these proceedings. I've prepared a written submission, which I think has been handed up to you. What I intended to do was to, first of all, to indicate that for the purposes of today's time slot that's been allocated to my client, I'm going to use that to make some opening legal submissions and address what my client considers are the key issues of concern to it in the proposed regional policy statement. I don't propose to call any of the Oceana Gold witnesses at this point. And I'll note that Ms. Paul, one of the witnesses, is here today, and if there are questions which you have for me which I can't answer and she can, I hope that she'll jump in and assist. And I think Ms. Hunter, their planning consultant, may also turn up at some point during the presentation. She's also available to answer questions. My intention is that the witnesses for Oceana Gold will attend and speak to their evidence when we get to the detailed topic areas that they've particularly given evidence on. And if you've scanned ahead, you'll note that there is extensive evidence from Oceana Gold experts, particularly in the area of the eco check. And so you can expect to hear from those experts when we get to that part of the policy statement. By way of introduction, I wanted to make a comment, with your leave, about the issue of the overlap in processes between this process for the non-freshwater parts of the RPS and the freshwater parts of the RPS. The main comment that I want to make is around the importance of thought being given to the natural justice requirements of dealing with this. I was going to say an unusual situation, but when you contemplate it and you think about the next generation of regional policy statements that, whatever they become under a new regime, this issue of overall integrated documents that traverse both freshwater and non-freshwater topics is going to be something which councils have to deal with. It seemed clear from the decision of the High Court that what the legislation anticipates is that documents which cover the whole field, if you like, need to be split. But there isn't such a thing as an integrated approach, which means that everything is freshwater. And of course, that was the proposition, if you like, that the regional council tested in the High Court, and the High Court said no, that's not the case. So we have to proceed on the basis that Parliament has anticipated that there are going to be situations where you have instruments which are part freshwater instruments and part not. And that's what, of course, we're confronting here. The second observation is, of course, that Parliament has made no special provision in a procedural sense for when that situation arises. And so you are confronted in my submission with the position that you need to avail yourselves of the normal tools that are available to ensure good process. Parliament hasn't provided you with something different in order to get around, if you like, the complexities that are caused by this dual process. The next point is that as a matter of efficiency, common sense, and reality, you can anticipate that there's going to be an overlap in membership of panels on these instruments. It makes perfect sense that you do have that sort of situation. It may not be universal overlap, but there may be common members of the panels. A particular concern from a natural justice point of view arises in that sort of scenario, I submit, and that is the danger of the panel effectively taking on board information it receives in one process and using it in another. And so my caution to you is to be on guard about that, but at the same time to expect that you will hear information in one forum which is relevant to your work in another, and you must work a process to deal with that. And I can think of two ways that might be achieved. One is through the way that you as a panel utilise your ability to question participants in the process. So if you hear something in this process which is relevant to matters which are raised in the freshwater process, ensure that you raise those with the participants in the freshwater process. And that way that information is then, if you like, on the table in the freshwater process, and that process can't be criticised. The other mechanism that occurs to me is to invite the regional council, which of course is a leading participant, if you like, in both processes, to make submissions to you about what has happened in the other process, and to do that in an open hearing way. Once again, that then gives opportunities for other parties who perhaps are participating in this process to become apprised of relevant matters that have arisen in the freshwater process, and to offer comment on it should they wish to do so. So those are my comments. I hope they're of some assistance, but I'm conscious of the fact that this is sort of this new territory for us all. And I suppose one of my professional interests, I suppose, and work that I've done over the years is in trying to encourage good decision making. And I think that kind of always thinking about transparency and the rights of participants in the process to understand the information that is relevant to your decision making and have the opportunity to comment on it if they feel they need to, is paramount. The second preliminary comment that I'd like to make, and I come to it in the context of my written submissions, which of course I prepared before today, it is to do with this issue when it comes to the extractive sector, of whether or not issues of relevance to that sector should be dealt with in a discrete part of the RPS, or whether they should be on a topic by topic basis addressed or sprinkled through the RPS. Now, as the other Ms. Boyd and the other planners who have spoken to you today have reflected, my client's planner has prepared some suggested wording on the basis of a, if you like, a more discrete way of dealing with the issues that are relevant to that sector. And the other planners, Ms. Boyd and the others, have indicated that their preference is not for that, but to see the issues of concern dealt with as they arise in the various chapters, whether that be the eco chapter, land and freshwater, urban form of development, whatever it might be. I can indicate that, first of all, I believe it is Ms. Hunter's preference as a planning expert that the topic be dealt with in a discrete way, such as is done in the RPS for infrastructure and energy and transportation. From my client's perspective, it's not wedded to that. And the overriding concern is that the issues are, in fact, dealt with in the RPS and not ignored, which is the status quo, if you like, in the proposed plan. So I was greatly encouraged by or heartened by Ms. Boyd's comments this morning when she indicated that somewhat belatedly in my client's view, but the Regional Council is now turning its mind to how it might address the issues of concern to the extractive sector in a different way from the way that Ms. Hunter has proposed, but nevertheless to get at the issues that are relevant to my client. So on that basis, I would say, as things stand today, my client reserves its position on whether or not it prefers a discrete or a sprinkled through approach, and we'll wait with interest to see what the council plans come up with. I agree with this comment that Ms. Boyd made in opening today that providing evidence or information on in an overview way is fine to do at the beginning of the hearing, but it's probably also necessary to do it again at the end. And so that's a topic to which we'll return in closing once we have once some water, if you like, has travelled down the river, and we have a better understanding of how the whole thing might hang together and what the council's preferences are for the way that the document should be integrated or woven. So with that, by way of an introduction,
Just saying, Mr. Chris, I'll just keep myself clear in terms of what you just said. Are you anticipating or seeking really the opportunity to have a further set of submissions once you're aware of what the Section 42 recommendations might be on a chapter by chapter approach?
Yes, I am making that application.
Yeah.
At the moment,
I probably can short circuit you by saying that I think that's fair, and it's an unusual approach in the way in which we would approach all other submitters to date. But I accept the point you make that the way that it's developed has meant that you won't have had the opportunity of seeing those until they're discussed on a chapter by chapter basis. So,
that's right, and I think it's also, if you like, compounded by the fact that the region has to deal with the 2022 amendments to the National Policy Statement for Freshwater Management, which has definite requirements so far as the mining sector is concerned. It needs to be addressed in the regional policy statement and given effect to anyway. So once again, how the region chooses to undertake that, we don't know yet, and that's the subject of it'll be the subject of further evidence which has not yet been provided, and which my client will want to respond to in some way. So it's a little bit.
There will be a minute coming out about that, setting dates, which I think from memory were.
I think it's the end of February for the council, and the end of March.
24th of February for the council, 31st March for some minutes.
Yes, yes. Mr. Logan was kind enough to share that with me today. So, so that's helpful. And I don't know whether, in terms of Ms. Boyd's program, whether she anticipates that the evidence that she produces at that point might go further than just the NPSFM requirements and address the broader topic of what needs to happen with mining or not. I'm unclear on that.
Ms. Boyd's here. What are your thoughts on that?
Part of the difficulty with addressing the mining topic is that the amendments sought by Oceana Gold span a number of chapters of the RPS, and I'm not the primary author of or the reporting officer for those other chapters. So it's not going to be, I can respond to the amendments sought to the land and freshwater chapter and the general proposition for separate chapter, but the amendments sought to the eco chapter are not within my realm. And so I don't see a difficulty with responding to the land and freshwater amendments sought in that supplementary statement that I'm preparing on the NPSFM amendments. But I would caution that that won't address the full suite of amendments sought by Oceana Gold in respect to the other chapters.
As the only council present for the council at the moment, can I impose on you to go to those other chapter writers, hopefully today or tonight, and come back to us whether they can meet that timetable, because it would be far more convenient if we were all working in the same timetable as 24th February for those amendments to those chapters. And Ms. Boyd can help us make sure that you're approaching the right chapter writers, and if you could have a response for us tomorrow, before we finish tomorrow.
Yes, can I just,
So that in a minute that I issue as to timings that arise out of this week, which I intend to do on Friday, hopefully I'm informed and I can inform it.
sure, can I just clarify? So the 42 recommendations have been undertaken in a chapter by chapter basis, and I was just talking to Felicity. Was OGL expecting another lot, aside from the NPSFM amendments and how they work together here, another lot of evidence in which it responds to? And these sort of matters we anticipated would be dealt with in the council's reply. So I'm just clarifying, do you want?
Well, the feeling, I think Mr. Christensen and I have both got a similar impression from what Ms. Boyd said this morning, that there was a way of responding specifically to the Oceania Gold's proposal, not in a discrete way, but by the sprinkle approach through the chapters, and that as I understood it, and I think Mr. Christensen's probably taken the same from Ms. Boyd, that was going to be addressed on a chapter by chapter basis. If it's already in the evidence, if that's your position or the chapter writer's position, then there's nothing further that needs to be done other than Mr. Christensen responding, and he can do that by the 31st of March. But if there is further amendments that are needed to be done or suggested, then what I'm asking is, can they do that by the 24th of February so that we can then stick to that same timetable?
My only hesitation is in regard to the eco chapter, because those deadlines fall before that hearing commences. And I'm aware that there is technical evidence, not only from Oceana Gold, but also from other submitters that is relevant for that chapter and is affected by what Oceana Gold is proposing in terms of the amendments to that chapter. So I'm not sure in advance of hearing that other technical evidence whether the author for the reporting office for the eco chapter could helpfully make any statements within the time frame that we're talking about. Because essentially what would be occurring is a statement from her with no further evidence on the topic since she produced her last statement.
In reality, though, in terms of the evidence, there is no further opportunity for Oceania to be producing any further evidence. So she should be in a position of being able to rely on that evidence and then responding with whatever planning recommendations she wants to make. The purpose of the hearing process is to highlight aspects of that evidence, but the evidence itself should not be being changed significantly. So I would still urge, if we can,
yes,
to try and have those amendments done, if humanly possible, by the 24th of February, and an indication tomorrow as to if it can't be done. Well, I'd certainly want a date specified as to when it was.
Yes, that's that. I don't imagine any difficulties with. I've just been looking at the scope of the amendments and looking at the other chapters involved. I don't foresee any difficulty with getting with any of the other amendments all across the other chapters. It's really only the eco chapter where the timeframe might be a bit challenging, but we're happy to go and talk to the authors and
Come back tomorrow.
Yeah.
Thank you.
If I can just so I don't want to prolong the point, but in terms of the eco chapter, I think I'm right about this. There are really three parts of it, so far as my client's concerned. One is quite straightforward, and it's going to be a binary answer from the regional council. Is it going to make provision for activities, mining activities, which cannot avoid effects on significant natural areas, to have access to some kind of effects management cascade? At the moment, it doesn't, and that's a key issue. The other two issues, which are important but don't go to the foundational issue. One is what are the significance criteria? So what criteria should apply for a significant natural area? And the second is what are the criteria or the principles that should apply in the biodiversity offsetting and compensation appendices. Now, those are both those last two letters, the appendices for offsetting and compensation, and the criteria for significance are hardcore ecological technical questions, which, as you'll appreciate, so ecologists will argue about forever and never get to an answer on. The primary issue, though, is does the regional council seriously contend that the 180-degree change in its policy from recognising the locational constraints of mining in the partially operative RPS to not doing so in the proposed RPS, does it intend to hang on to that? Thank you.
Thank you. I just want, before you move on to your written submissions, just one evidential matter arising out of the briefs that we received. The one by Mark Christensen commenced at paragraph 20.
Okay.
I'm not quite sure. Can I tell you what the lighthearted reason why I took some interest in that was because I saw the name and thought, is that the bloke that I knew who was a barrister? And but when I went to see what his background was, it wasn't there. The evidence commenced at paragraph 20. Checked with other panel members and we're all the same.
Right. Well, I don't know whether it's a photocopying issue or whether it's an issue at my end and not having filed the evidence correctly. So I will make sure that we look into that and get the answer. Sorry, get a full.
And what's the other answer?
The answer is the answer is that Mark Christensen isn't me, but he is my brother,
Right.
and he is a solicitor, but he's also an expert in biodiversity offset policy. So I've called him as an expert in that capacity.
Right. So the missing
links
will have all his
describes all of that. That's right. Right. Sets out his qualifications as an expert.
Right.
Thank you.
Thank you.
So finally, we get to the submissions. In my introduction, I say mining is regionally significant in Otago. It has played a major part in shaping the region and continues to be important today, contributing around 4.5% of the regional GDP and providing many direct and indirect jobs and associated social benefits. To quote from the proposed regional policy statement itself, Otago's economy centres around agriculture, tourism, mineral mining and education. A significant proportion of that regional contribution from mining comes from just one operation, OceanaGold's Macraes mine. To put things in context, and I'm referring to 2021 figures, which are referenced in Shima Biwiakab's statement of evidence. Macraes mine has successfully operated for more than 30 years. Today, it employs over 600 people directly, and when indirect employment is included, that total for the Otago region reaches over 1,100 and over 2,200 employees across the whole country. Macraes mine injects $122 million per annum into the regional economy, and exported gold and silver earns the country $343 million. All of these significant benefits will be lost in the future if the Macraes mine is unable to access further mineral resources because of the approach taken in the proposed regional policy statement. OceanaGold is New Zealand's largest gold and silver mining company, with active mines at Macraes mine in the Otago region and also in the Waikato region at Waihi. OceanaGold also has interests in the West Coast region, with one mine in closure phase, the Globe Progress mine near Reefton, and another mine in which it has an interest as a joint venture partner under development. It's the Blackwater mine near the former mining town of Waiuta. OceanaGold is ultimately owned by OceanaGold Corporation, or OGC, if you follow the shares, a listed company with a wide international shareholding that features the larger managed funds that form part of many New Zealanders' KiwiSaver investments. OGC also owns and operates other large mines in the United States, in Hale, which is in North Carolina, and in the Philippines in a place called Didipio. The demand for the metals produced by OceanaGold and the OGC group mines continues to grow internationally as we respond to climate change by transitioning away from fossil fuels towards renewable energy and more efficient energy storage. OGC, along with the mining industry globally, is actively looking to increase the contributions of its existing assets and to bring new assets into production to meet demand growth. Macraes Mine is located in the Hyde Macraes Shear Zone, a geological feature that accounts for the presence of large amounts of gold and silver. The Hyde Macraes Shear Zone is a remarkable natural feature in both the regional and national context, and the associated mineral deposits make the Macraes Mine a world-class asset. And that term is, if you like, a term of art, and Ms. Paul in your evidence explains what that means, but essentially these are very big mines, and a very small proportion of mines internationally meet that threshold. The Macraes Mine is well placed to make a meaningful contribution to meet global demand for metals in the coming years. In figure 2 of the proposed regional policy statement on page 64, minerals have been omitted from the list of the region's important natural resources, although mineral extraction is listed as a user. OceanaGold submitted that this omission needs to be fixed, and the section 42A report recommends that minerals be included in the figure. The omission of minerals as an important natural resource from figure 2 in the notified version of the regional policy statement is symptomatic of the policy statement's overall failure to address the importance of minerals and their future development in a responsible way. Originally in native forest, the Macraes area has been largely cleared for farming purposes, and today, in addition to mining, the Macraes area is predominantly used for farming and plantation forestry. The area was mined historically for gold and also scheelite, giving rise to a rich historical context combining farming and mining activities, as well as some mana whenua values. Pockets of remnant indigenous vegetation are widespread in the area as a result of the topography, with deeply incised gorges and rock outcrops having effectively formed barriers to clearance and farming development. Almost without exception, as a result of the extent of clearance over the years for farming purposes throughout the area, those pockets of indigenous vegetation that remain are significant and often contain plants that are listed in the New Zealand threat classification system. The wider Macraes area is sometimes referred to as a biodiversity hotspot. To be clear though, the reduction in biodiversity in the Macraes area from that which would have occurred prior to changes made by human occupation are generally not attributable to mining. In the broader context of the Macraes ecological district's footprint, in the broader context of the Macraes ecological district, mining's footprint and impacts are small. I talk next about the functional needs of mining. In footnote 7, I refer to the definition of functional need in the National Planning Standards, and it's in my submission particularly relevant to mining. It means the need for a proposal or activity to traverse, locate or operate in a particular environment because the activity can only occur in that environment. And I note in footnote 7, in the case of mining, it can only occur where economically recoverable mineral deposits naturally occur. The nature of the deposit dictates the methods of mining that must be used, that is, whether it can be mined by surface or underground methods, and also determine the infrastructure that's needed to support mining, such as storage areas for waste rock and tailings, for processing, and for associated infrastructure. So returning to the text at paragraph 8, the functional needs of modern mining are such that where important mineral deposits co-locate with these vegetation remnants, the loss of that vegetation often cannot be avoided when mining development proceeds. This means it becomes necessary to consider the full effects management hierarchy, including mitigation, offsetting, and compensation, to ensure that good outcomes for biodiversity are obtained at the same time as development of important mineral resources take place. In addition to remnant indigenous vegetation, the wider Macraes area provides large areas of habitat for a variety of indigenous lizards and skinks, some of which are also listed in the New Zealand threat classification system. The same principles apply where mining development cannot avoid areas of habitat for these important species, and full access to the effect management hierarchy is required. The Macraes area also contains many streams and rivers, some with good biodiversity and ecosystem values. Wetlands too are common, although many are in poor condition with little biodiversity value because they occur on farmland and are not managed for biodiversity and ecosystem service values other than as a source of stock water. As with terrestrial values, loss of or adverse impacts on aquatic values cannot always be avoided as mineral development takes place. Mining is not unique in having locational and functional needs that mean adverse effects on other important values cannot always be avoided. But I note in footnote 9, and this goes back to my comment earlier about what functional need means for mining. And I note that the constraints on mining are often more significant than for other activities which may have other more expensive or inconvenient options to avoid adverse effects on significant values. A road or power line, by way of example, may be able to avoid an area by taking a longer or more technically challenging route. For mining, the position is binary. An inflexible requirement to avoid adverse effects in an area where economic mineral deposits occur will mean the mineral development opportunity will be lost, along with all the benefits that entails. In paragraph 11, mining is not unique in having locational, I've read that paragraph. This reality, that sentence, this reality for mining and for other valuable activities such as important infrastructure, landfills, quarrying and significant urban development is recognised in operative and proposed national statutory planning documents by ensuring that strict avoid policies are not applied universally and exceptions to such policies are provided. This approach is also found in the partially operative regional policy statement for Otago. It is not remarkable or revolutionary. It's reasonable and necessary to ensure that the well-being of people and communities is provided for and that other important values on which adverse effects cannot be avoided are also addressed and good outcomes achieved. Aside from the economic importance of mining to Otago's economy, the avoidance policies of the proposed regional policy statement are inequitable in their effect across different land uses. Like infrastructure, mining's large landforms are disproportionately impacted by avoidance policies. Fencing off a small wetland in the middle of a paddock costs the farmer a single stock unit per season. The same wetland could stop a bridge, a power station, or an open pit, with all the economic losses and job losses that entails. I turn now to the special purpose zone in the mining zone in the Waitaki district. Since the operative Waitaki district plan was put in place, the mine has expanded such that it now also includes components located in rural zone land in Waitaki and Dunedin City. And I just made the observation at paragraph 11, the Waitaki District Council is in the process of developing a new district plan, and that's expected to be notified, I understand, early next year. And my client's expectation is that the boundaries of the mining zone will be amended to reflect a more contemporary, the more contemporary footprint of land ownership and mining development. So in other words, the boundaries of the mining zone have just become out of date over time as the mine has developed and changed, and as my client's land ownership has increased or at least changed in the area. I make the comment that in paragraph 13 that Macraes mine is large and complicated. It comprises open pit and underground mines, waste rock and tailings storage facilities, a large processing plant, freshwater storage, explosives and hazardous substance storage facilities, workshops and offices, and a large amount of supporting infrastructure in the form of roads, water pipelines, electrical lines and services, duns, silt ponds, and so on. The mine operates under approximately 200 resource consents, mostly issued by Otago Regional Council, but also including land use consents from the Waitaki District and Dunedin City Councils. Those consents are issued subject to many conditions with which OceanaGold must comply and which ensure the effects of its activities are managed appropriately and for the sustainable management purpose of the RMA. Macraes mine has successfully consented multiple activities at the mine site over the past 30 plus years and has an excellent compliance record. OceanaGold is a leading and very responsible operator. It maintains active and healthy relationships with its key stakeholders, including the local farming community at Macraes, the Department of Conservation, the Waitaki District Council, Kaitahu, and the consenting and political arms of the Regional Council. All naturally occurring gold and silver in New Zealand is the property of the Crown. At Macraes and elsewhere in New Zealand, OceanaGold operates under the authority of mineral permits issued to it by the Crown. These permits authorise OceanaGold to prospect, explore and mine for Crown-owned minerals, subject to a range of conditions around matters such as minimum levels of expenditure and reporting. Where mining occurs, OceanaGold is required to pay the Crown a royalty. The royalties paid represent a fair financial return to the Crown for its minerals, and in 2021, the company paid the Crown royalties of $4.1 million in respect of the Macraes mine. Mining of Crown-owned minerals is recognised nationally as an important activity. The purpose of the Crown Minerals Act is to promote prospecting for, exploration for, and mining of Crown-owned minerals for the benefit of New Zealand. In order to pursue that beneficial activity, OceanaGold has purchased the land that it mines at Macraes. Because of OceanaGold's international ownership, all land acquisition has to be approved under the Overseas Investment Act, which ensures that where land in New Zealand is purchased by an overseas person, an appropriate benefit to New Zealand will follow. The purchase of land for the purpose of mining activities at the Macraes mine has consistently been found to readily satisfy that test. So what is OceanaGold's issue with the proposed regional policy statement? Unlike the partially operative regional policy statement, the proposed statement fails to make appropriate provision for the ongoing needs of mining in Otago and at Macraes mine in particular. The proposed statement contains no direct policy recognition of the importance of mining as an activity in the region, and no policy support for the development of the region's mineral resources. No policy recognition of the locational and functional needs of mining and associated activities to take place where the minerals are naturally found, and no supporting policy to manage the tension where important mineral values and other important values coexist, and avoidance policies that inequitably and disproportionately disadvantage the realisation of those mineral values. OceanaGold does not necessarily seek a separate policy framework for mineral development within the new RPS, but does seek changes to parts of the document to address the above deficiencies. Those changes will be discussed in more detail as this hearing proceeds, but principally in my submission need to occur in, firstly, the land and soil chapter. This part of the regional policy statement deals with the identification and protection of land that is important for primary production. Mining is a valuable form of primary production, but as notified and is now recommended in the Council's 31 October version, the LFLS chapter ignores this and ignores the risk to mining from a failure to recognise and provide for access to important mineral resources and the importance of ensuring those mineral resources are not sterilised. The notified version conflates provision for primary production with protection of highly productive land for food growing. In other words, the provisions only address part of the primary production sector and do not currently address the regional issue of the identification of and ensuring access to important mineral resources as another aspect of primary production. And then in the ecosystems and Indigenous biodiversity part of the plan, of the policy statement, this part of the policy statement deals with, amongst other things, the identification and protection of significant Indigenous biodiversity values. Unlike other regionally important activities that are locationally or functionally constrained such that they cannot always avoid adversely impacting significant values, the current wording entirely fails to recognise this reality for mineral development. Future development of the Macraes mine will make an important positive contribution to the region through the provision of jobs, economic and social benefits, and net biodiversity enhancements. As notified in the proposed policy statement, and as proposed to be amended in Council's evidence, these future benefits will be foregone and the many jobs provided by Macraes mine will be lost. This is because the future development of the mineral resource will involve unavoidable adverse effects on areas that qualify as significant natural areas. Unlike the recently completed partially operative regional policy statement and inconsistent with national direction, the proposed regional policy statement fails to recognise the need to manage this tension. The result is that, as currently worded, further development of the Macraes mine's world-class mineral resources would be frustrated because mineral development's locational constraints are not recognised and adverse effects on SNAs are simply to be avoided. In opening submissions, Mr. Logan for the council explained why the council was proposing a new RPS when the partially operative RPS's ink was barely dry. He indicated the following reasons. Firstly, the findings of Professor Skelton in his investigation for the management of the environment into the fitness for purpose of Otago's freshwater management regime, the introduction of the national planning standards, and the introduction of the new national policy statement for freshwater management and for urban development in 2020. In my submission, none of these reasons provides any justification for the wild change in policy now promoted in relation to mineral extraction, and there have been no other policy developments that support such a change. There is nothing in the national planning standards that precludes a regional council from identifying and addressing important regional resource management issues, and indeed to infer that the required framework under the national planning standards has that effect. In other words, to say there is no chapter or a topic of the national planning standards that readily lends itself to deal with minerals, so we'll just ignore them. To do that is inappropriate and cannot be reconciled in my submission with the purpose of a regional policy statement under section 59, nor the mandatory contents of an RPS as set out in section 62. The position taken in the proposed regional policy statement regarding the extractive sector is a major departure from the partially operative RPS. It is inconsistent with operative and proposed national direction. The effect that the proposed policy position would have on Macrae's mine, its employees, and all those who rely upon it, and consequently on the Waitaki and Dunedin City districts in particular, has been explained on numerous occasions to ORC staff and consultants, but appears to be met by bewildered disbelief or confusion and no attempt to fix the problem the notified wording creates. The overall failure of the proposed regional policy statement to address the regional importance of the extractive sector is addressed at paragraphs 195 to 212 of the section 42A report 1 at pages 44 to 51. So far as Oceana Gold's submission is concerned, the analysis I submit is incoherent. At paragraph 205, I've quoted from the report. If that is true, then why does Eco P4 identify some economic activities that are to be treated differently where they impact on significant natural areas? The framework that has been put in place will result in the use of important mineral resources being unavailable because they co-locate with significant natural areas. This is a complete reversal of the approach in the partially operative RPS, and yet no attempt has been made to explain what has fundamentally changed such that this new approach is justified. The current failure of the eco provisions to identify mineral extraction as a regionally important activity that at times will not be able to avoid impacts on significant natural areas is surely an example where an alternative pathway must be provided, as is the case for infrastructure and important uses of Māori land, as contained in Eco P4. As noted above, avoidance policies are disproportionate in their effect on large, structurally constrained and regionally important land uses. Some of those uses are recognised in the proposed regional policy statement by ensuring that they are not cut off at the avoid pass. But mining is not, and that is neither appropriate nor equitable. At paragraph 208, the report states, I note that the submission of Oceana Gold specifically highlights the provisions of the eco chapter and helpfully sets out in detail the issues that arise from the application of those provisions to Macrae's mine. But then, I'll leave you to read what the report goes on to say at paragraph 211. Given the acknowledgement in paragraph 208, the subsequent statement at paragraph 211 makes no sense as regards the impact of the eco provisions on the Macrae's mine. The Oceana Gold submission goes to great length to explain exactly what the problem is. As Dr. Thorson states in the ecological evidence forming part of the Oceana Gold submission, the areas that are proposed to be developed as part of the extension of the existing Round Hill and Golden Bar mining areas within the Macrae's mine footprint include areas that have a high or very high probability of being determined to comprise significant natural areas. On the current wording of the proposed regional policy statement, such development would not be provided for, irrespective of the extent to which effects on the values in the SNA were being addressed so as to provide for a net biodiversity benefit. In supplementary evidence, Ms. Boyd addresses a set of proposed changes provided by OceanaGold to address the deficiencies of the proposed policy statement regarding provision for extractors. These were provided out of a sense of frustration at ORC's refusal to engage constructively on the topic, despite establishing consultation reference groups. Paragraph 62 to 69 of the supplementary evidence discusses the eco provisions, and Ms. Boyd recommends no changes to those provisions. I submit that position is untenable. The Regional Council is aware of the significance and contribution of the extractive sector and Macraes mine in particular. The Council is aware of the issues that arise from the application of the notified eco provisions for Macraes mine. Future planned extensions will overlap with significant areas, and a consenting pathway allowing the effects management hierarchy to be considered must be maintained. An absolute avoid policy regarding adverse effects on significant natural areas and the ongoing provision of the Macraes mine's many benefits cannot coexist. The National Policy Statement for Freshwater Management provides for this consenting pathway so far as wetlands are concerned and must be given effect to. The exposure draft of the National Policy Statement for Indigenous Biodiversity also provides this consenting pathway. A consenting pathway is maintained for other nominated regionally important and locationally or functionally constrained activities consistent with the exposure draft NPSIB. A consenting pathway is provided in the partially operative RPS, and nothing has changed in the short period since those provisions were developed that justifies a complete policy reversal. On the contrary, the changes that have occurred are, firstly, clearer national direction supporting the requirement for mineral development to have access to the same consenting pathway as other important locationally or functionally constrained activities. Second, recent successful consenting experience at Macraes mine of an important development of a previously mined area called Deep Dell Stage 3 that would not have been possible had the eco provisions in the notified regional policy statement been in place. And I note that, so ironically, the Regional Council was both a consent authority and submitter on that application. Thirdly, clear and unequivocal information provided to our ORC by OceanaGold showing that future plan developments at Macraes mine will unavoidably affect the areas that will be assessed as significant when ecological evaluations are undertaken. And finally, further information that some biodiversity continues to decline in the face of pest and predator pressure and uncontrolled or poorly regulated human activities. I just want to pause there to say that I think that in some people's minds there is a conflation of the idea of maintaining some kind of an opportunity to pursue a resource consent and the granting of an inappropriate consent that allows an activity that shouldn't occur. And in my submission, that overlooks two factors. One is that resource consent decision making is not undertaken by fools. They're people who are trained and know how to apply the policy framework and the legal requirements to the facts. And they make decisions about what they consider promotes sustainable management in the circumstances, having regard to all of the relevant policies, all of the relevant information about effects and so on. The second point that comes out of, I think, the evidence of the ecologist, Dr. Boyd for the Regional Council, would imply that, oh, well, sometimes people don't do the things that they say they're going to do when they get their resource consents. Well, that may be true in some instances, but that is not a reason for writing bad policy. It's a reason why councils need to enforce the consents and why consent holders should do what they say they're going to do, and why if they don't, they should be held to account. My client is horrified at the thought that if, in the face of accusations that in other places biodiversity offsetting is not done well, it should be not allowed to access that tool. That's simply poor policy in my submission. Much more will be said, paragraph 35, much more will be said on this topic in the evidence and submissions as the hearing proceeds. What I will say now, though, is that there is an inconsistency in the ORC's thinking that the panel will need to make a call on. The section 32 report at paragraph 440 on page 130 discusses the approach purportedly taken in the drafting of the eco provisions. And I'm going to read this. Right? Option 4, which is what's notified in the document, seeks to retain elements of the proposed regional policy statement 2019 provisions that continue to be appropriate and relevant, while improving the clarity and drafting of those provisions and aligning the policy framework more closely with the draft NPSIB. And note, that's not the exposure draft. This was an earlier one. It's moved on. It's even become more clear since then. It is acknowledged that this document is currently in draft form and has no legal weight. However, it does indicate the government's most recent policy position on managing Indigenous biodiversity and has been developed over many years with input from a range of stakeholders and experts. So that's what the Council said in its Section 32 report. By contrast, the subsequent supplementary evidence is void for the Council at paragraph 57 and 58, and I won't read that quote, I'll let you have a look at that. The position outlined in the maintenance amendments by Mr. Logan reflects Mr. Boyd's opinion. Mr. Logan did not address the ORC Section 32 report, which says quite the opposite. While it must be true that the final form of the NPSIB may not be identical with that of the exposure draft, that rather misses the point, at least so far as my client's interests are concerned. The draft NPSIB in all its iterations, from the initial concept developed by the Biodiversity Collaborative Group to the most recent exposure draft, has always contained a recognition that some consenting pathway for mineral development must be maintained where those minerals intersect with significant natural areas. Sustainable management and the enabling of people and communities to provide for their well-being require it. The partially operative RPS provides it, and the Macraes mine cannot survive without it. It is incredibly short-sighted of the ORC to proceed on the basis that there is no NPSIB in place and to refuse to acknowledge its clearly signalled policy direction or the implications of that for the proposed regional policy statement, and instead to promote an approach that effectively says to a major regional industry that consistently meets its resource management obligations that it will only provide for it begrudgingly if national direction forces it to do so. Such an approach makes very poor policy. Providing to mineral development the same access to a consenting pathway as is provided for other important constrained activities is not a recipe for biodiversity decline, and it is not an exception. It is an opportunity for an applicant to design and promote an approach that ensures impacts on biodiversity are at worst net neutral and preferably net beneficial. If that cannot be shown, then a proposal should expect to struggle to gain approval. OceanaGold has demonstrated it knows how to get the job done. It invests in major biodiversity initiatives as a key part of its business because that's what it needs to do to stay in business and because it is the right thing to do. It only seeks the opportunity to continue to do what has been working so well in recent years to both secure the ongoing benefits of mining and to ensure that other important values are appropriately recognised and protected and in many cases enhanced. OceanaGold is eager to continue to contribute to this hearing to assist the panel as you work your way through the various provisions. Without doubt, the document in its current form is unacceptable to OceanaGold and must be amended to address the failings identified in the company's submission. It simply cannot be right to make operative a policy statement that unnecessarily spells the end of future development of Otago and New Zealand's largest and most successful operating mine, with all that entails for employment and people's well-being. Previous consent applications at Macraes mine have been granted on the basis of evidence that unavoidable effects on the values of significant natural areas are able to be successfully managed to produce good outcomes, and that further development of the mineral resources in those circumstances promotes the sustainable management purpose of the Act. It cannot be right to make an operative policy statement that pulls in the opposite direction to what central government is saying, even if central government cannot, for whatever reason, get on and formalise those policies. OceanaGold would welcome the panel to the Macraes mine for a site visit and hopes you will have the opportunity to view the mine workings and some of the many environmental and biodiversity enhancements that are undertaken. OceanaGold and its staff and contractors are proud of what they do. They are enthusiastic to show the panel why the direction of the notified proposed regional policy statement in seeking to prevent further developments at Macraes mine is such a very poor choice.
Thank you, Mr. Fritton. Maybe questions?
Yeah, thank you. And thanks for painting a bit of a picture for us about Macrae's, and I assume that we will be getting further evidence on that too. I haven't delved into the evidence too much, but given that I'm not from around these parts, I'm just wondering, and I know this might not be the right question for you, but given we've got your opening submissions, it would be good to get a little bit more of a picture around this. I suppose I'm just interested in overall how the mine works. Obviously, you've got quite a large area that's owned. There's expansion plans in process. How do you sort of work in terms of, the part of the pit that's open, what happens when you close areas, how do you sort of move on into new areas, reinstate areas that have been closed, that sort of stuff? You've got a very 101 version of that.
Yeah, I have. I'm a lawyer, right? So I'm not a.
I appreciate
I'll
that.
have a go, and the people that work for Mike can laugh and do it.
I'm just putting it there.
Okay, so the obviously the where you go mining is built around what your exploration activities tell you about where the resource is, and in what concentrations in the ground. Is it economic to recover it, or is it, would you put a whole lot of effort in and spend a whole lot of money and not get much for a return? The location of the gold will also, gold and silver will also determine the way that you go mining. So do you dig a pit, or is it deep and really concentrated so that you can economically go target underground and go and get it? So those are all kind of technical issues there.
So it's different methods underway.
Different methods. That's right, and both underground and surface mining is used at the Macrae's mine, depending on the nature of and the location of the resource. When mining started in around about 1990 at the Macrae's mine, this is the modern mine. It was centred on one area called Round Hill. And the company built a processing plant and a tailings facility and a place to store waste rock, and went about excavating this pit called Round Hill. It then engaged in over the next let's say 25 years in successful exploration campaigns, which were then associated with further applications for expansion of the mine, so new pits and new underground mining. Where it could, the policy was always to keep the footprint to an absolute minimum, and you do that by, for instance, if you've already got a hole in the ground and you can manage it, you put your waste rock from your next hole or your tailings into that existing hole, so you minimise your footprint that way. All of the mining developments are, of course, subject to detailed rehabilitation requirements in the resource consents, and that's poured over by the ecologists, by the landscape architects, and so on, to ensure that these are large earthworks, and to ensure that they're done in an appropriate way. In more recent times, because the process plant is fixed in location, the further you move away from it to do your gold mining, the less economic it is. And so attention has turned to a lot more attention has turned to getting more out of the area that's been mined previously. So in these latest proposals that the company is looking at, it's looking at, I mentioned Round Hill, and I also mentioned another area called Golden Bar. These are areas that were mined previously, and the company's now going back and saying, hey, there's still a good resource there that with more efficient methods that we've got today, and with the changes in gold price and so on, it makes sense for us to look at those areas because they're really close to our existing infrastructure as well. So the other thing I'd say is that the company does a lot of optioneering. I've sometimes been involved in as a lawyer in terms of assessing options. When you do have locational constraints in terms of where the gold is, there's not much you can do about that. But you will have choices to make about where you locate other infrastructure, waste rock stacks, and so on. And so a lot of thought and effort goes into choosing the most suitable places on a multi-criteria basis. So not just looking at the cost, but also looking at the environmental footprint. what is it doing in terms of biodiversity? What is it doing in terms of landscape? What is it doing in terms of how close it brings that infrastructure to where people live and the noise and amenity effects that are associated with that? There's a whole host of things that the company considers as it goes about selecting the right option. And by way of example, in the Deep Dell application from 2020, there was quite a discussion around the prospect that some of these ephemeral wetlands were going to get lost under the footprint of the waste rock stack, and there was a lot of discussion about that. The alternative location, which the company discounted, would have put the waste rock in a stream, and the call was made that the effects of that were much greater. And so the environmental department, if you like, is of the mine. Its business is to guide the company into the most sustainable way of mining that it can. So I don't know, that's
Yeah.
a lot of comments that can be made, but
Yes.
it's quite a big and complicated business.
No, I've had involvement with quarries and mining operations before, but the mining operations have been at a much smaller scale than certainly the Macraes. But the other thing I was interested in comment on, and you've been involved in some of the consenting processes for Macraes as well. You made a comment, and I can't quite put my finger exactly where, about relationships with paragraph 15, about relationships with key stakeholders, and you do refer to Kaitahu there, and I'm not sure to what extent you've heard some of the evidence we've received over the last couple of days from Kaitahu, but some of the cultural witnesses were, they weren't saying overly nice things about you, I suppose, is probably one way to put it. And I'm wondering,
Not me personally, I hope.
No, not you personally. You're fine. But just, they did say they've got good relationships with some staff, but overall I think I got the impression that they're not overly impressed with the sort of overall direction of and the larger, sort of corporate willingness to engage. I'm wondering, in terms of consent processes, how is that played out with Kaitahu and their involvement in developing, mitigation, monitoring, any other sort of offsetting? I mean, they were particularly concerned about some of the sedimentation that's occurring around the coastline, but also loss of biodiversity value as well.
Well, I can't provide a complete answer to that because a lot of it's beyond.
And I appreciate that's something that we'll probably revisit with.
Well, the Oceanic people here have listened to that, so they'll be able to reflect on that and respond to. But what I would say in terms of the consenting efforts that I've been involved in, they're always part of that process involves consultation, as you'd expect, including with tangata whenua, or anything that's remotely significant. The opportunity to prepare a cultural impact assessment is provided. Certainly there's been times when the ability, the resourcing from NITO hasn't been available to complete the CIA work in a timely kind of way, and there the company has volunteered conditions that still require the CIA to be produced, and for the council to have the ability to review the consent if the CIA throws up issues. The suggestion that there are effects that are not accounted for in consent, I don't accept. The approach of the company is, leave no stone unturned kind of approach. So it would expect that if there are cumulative effect issues, those are 100% understood to be effects under the Resource Management Act. If there are effects that extend beyond the footprint in terms of into the awa, into the coastal environment, those are effects which it would expect to account for.
Yeah, and I think that's something. I mean, I'm certainly quite keen to explore that with some of the witnesses as well around, and not just in relation to resource consents, but what I suppose OGL doing towards sort of more of a sort of, partnership approach with Kaitahu or anything, given, there, and particularly, given we've received evidence from the Mana Whenua chapter and also the resource management issues that are of significance for EV2, and some of those issues really do sort of some things that we're going to have to hold in the forefront of our minds when we're looking at the amendments that you're requesting here.
One question. And paragraph 7, I'll read the sentence for you, reads, the area was mined historically for gold and also tungsten, giving rise to a rich historical context combining farming and mining activities, as well as some Mana Whenua value. I'm curious about the last bit of that sentence, as well as some Mana Whenua values. Are you able to enlighten me on?
Well, somewhat. It is, I think you'd expect, Commissioner, in that area of the country, it's quite high in inland. To my understanding anyway, there were no significant permanent settlements or things of that nature, but the area was, of course, used by Tangata Whenua as a route as they move through the country for hunting, for all sorts of purposes. And so there is evidence of habitation, but not on a large scale, but remnants of.
There's no normal there, for example.
No, there's no formal site, but there are archaeological records and areas that are recognised by Mana Whenua of that are significant for one reason or another. It's not as profound, I suppose, as some areas in terms of the significance of the area, but it's not off the map. It's an area that is known to Tangata Whenua and has traditionally used and has value.
And just to paraphrase the question I asked the previous person sitting where you are there about the location of the mine itself, how close is it to built-up settlements
so there's a small township called McRae's Flat, which is close by the mine, probably a kilometre from something like that from the nearest of the big airports. It's close. Yeah.
No, distance.
Oh, 1 kilometre.
1 kilometre. Okay.
Yeah. Well, that's my guess. Oh, there's a map coming up. Thanks, Kate. Or someone's doing that. Oh, you can't really tell too much from that. It's a small rural settlement. There's a hotel which I think the company owns the hotel and keeps it open for the local people to enjoy. And there's a school, a primary school, which would be closed if the mine wasn't there, because of the number of mine families that provide children to it. And that's true of probably half a dozen other schools in the local area. So it's I would submit from my observation over the years that the company has a very close relationship with its host community.
Thank you. There was actually 2 questions. Is the crazy?
So Round Hill and Golden Bar, where are those locations?
You can't see Round Hill. You'd have to zap out of it. But Round Hill is right in the middle. Gosh, where am I? Process plant. Probably about here, somewhere in here. The original area that was mine. That's Round Hill, and then to the south, and it's probably down about where the point of my pen is Golden Bar.
Oh, I see.
Quite a long way away. Right, somewhere
somewhere in there.
Thank you. I've got a few questions if I can. We about to get the 31 October version, but we've got the marked up 11 October version, and on that, page 80. Have you got that before you?
Thank you. Thanks very much.
At page 80, I take that's the figure 2 you're referring to.
Yes.
And you'll see at the bottom left hand quadrant, right hand side, just above the word impacts, you'll see minerals extraction.
Yep.
Your submission was saying that it wasn't included in figure 2.
So yeah,
And it's now included. Should that be one that's underlined? Is that something that's arisen out of your submission?
no, not quite. What's happened is that minerals extraction was always there.
Right.
And the bit that's been added in as a result of the section 42A recommendation is right at the top of the diagram, whereas minerals never is underlined.
Oh, right. Thank you.
So there was if you like, there was a bit of a disconnect because it was recognised that mineral extraction was a thing, a regional thing as a user, but the minerals, the natural resource that was being extracted wasn't recognised.
Right. Okay.
And yeah, that was
Thank you. Just in paragraph 7 near the end, to be clear, the reduction of biodiversity and praise that which would appear prior to changes made by human occupation is generally not attributable to mining. Are you suggesting that it's attributable to land clearance or something or prior to farming?
Yeah, it's the area that like so much of our country, the things that often we value, that this is the open landscape with the tussocks and so on, wasn't like that before we turned up. It was in forest. It was all cleared because the people couldn't use it for what they wanted to use, and so
when did that clearance occur?
Was
it Māori clearance or was it
originally burning and clearance, some by Māori, I think. I wouldn't want to be held to the fire on that, but certainly by European settlers for farming. There was a clearance that took place.
So what beach forest?
Not beech forest. It was
Right.
I believe so.
Thank you. Paragraph 13, you referred to the fact that it also includes components located in rural zone areas in Waitaki and Dunedin City. Is that the Golden Bar area?
No, curiously, if you look at the local authority boundaries, they go do all sorts of strange things, and the area to the north of the mine crosses over out of Waitaki and into Dunedin City towards the top part of Dunedin City, sort of peels up the Strathtyre Valley through Middlemarch and sort of terminates up at a place called Hyde, which is, if you like, on the way to heading up towards the Maniatoto and right, there you go. Yep. So that's in Dunedin City. It's a long way from Dunedin City, but it's part of the local authority. So the parts of the mine, if you like, that towards the top of the map actually cross over the boundary into Dunedin City.
Right. All right. Which leads me to, and I'm not trying to score points or anything, but was there a typo in paragraph 15 where Dunedin City was listed? Or was that purposely? No.
Oh no, there was no. I wasn't doing anything really cunning. Yeah. I suppose the reality is that it's a small portion of the mine that's in Dunedin City. If you like, the bulk of the action takes place in Waitaki. There's no issue with Dunedin City.
So the active and healthy relationships
they extend to the big brother as well. Correct.
Right. Good. Paragraph 20 clause B. you say that in the eco section that deals with Australia, identification of protections against indigenous biodiversity values, unlike other regionally important activities that are locationally or functionally constrained, current wording entirely overlooks mineral development. What are the other regionally important activities that you say that you're referring to here?
So I'm referring to Eco P4, which is on page 185.
That's nationally significant infrastructure or regionally significant infrastructure. Yeah. So you're saying that it's either the nationally significant infrastructure, regionally significant infrastructure, or the Manapeno activities.
Yeah. And then there's down the bottom there's if you like activities that are just kind of enhancement activities they're provided for as well. And there's no issue with any of those activities being included in that list. My client's saying, yeah, but what about us? We're locationally constrained as well, and what we do is important too.
I see the heading to that particular provision is provision for new activities. What's your view in terms of the status of an activity that's consent is expired? In terms of that policy, is it a new activity or not?
Yes, it is. If it's expired and it needs a new consent, I think that it would make sense for that to be included within that policy and being interpreted in that way.
Right. Okay. Paragraph 32. Your information was that your greatest line footprint includes areas that have a very high probability of determining the prize SNAs. And do I take it that you're compelled to express it that way because in reality you don't know until the lower level document, i.e. the district plans that are relevant, do that exercise?
No, not so much. I say that because as you'd expect, when you come to do a resource consent application, the ecologists go in and they do an assessment of the significance of the area that's in the footprint. The advice from the consultant ecologist is when I do that assessment, I will find that these areas are significant. And so you get, if you like, the area will be treated as significant, even though it's not been mapped in the Waitaki district plan as significant. And full disclosure, that's how it should be, because if an area is significant, it's significant. It doesn't lose its significance because a planner hasn't put a line on the map. Right. In my view, and so certainly my client would proceed on the basis that if it meets the duly set criteria for being significant, it should be treated as such.
Yeah. No, well, certainly if you take the Marlborough environment plan, for example, they adopted a policy of having a voluntary arrangement with farmers so that the SNAs are dealt with exactly as you described. Yeah. Paragraph 34 F, little Roman 1. So I've got that clear and national direction supporting a requirement for mineral development to have access to the same consent pathway. Is that the NPSIB draft form that you're talking about?
So there is the National Policy Statement for Freshwater Management as amended in December of last year, which provides a definitive amendment of the previous failure to provide for mineral development and quarrying and a number of activities that were effectively prohibited by the instrument when it was first gazetted in 2020. And in 2022, the government amended the national policy statement to make those changes. And I understand that's one of the issues that Ms. Boyd knows that the document has to address, her document has to address, and that's what she'll be attending to, is to, if you like, pick up what's changed. That's national policy, that's wetlands.
Yeah.
The draft national policy statement for Indigenous biodiversity, which we've talked about, also has that an equivalent for terrestrial values. And the national policy statement for highly productive land recognises that important mineral development. It recognises important mineral development as an exception to the need to protect highly productive land. So
that presumably is to enable aggregate quarrying around Canterbury, for example.
Yeah, and because with the highly productive land NPS, we've chosen class 1, 2, and 3. That's a lot of land, and it does overlap with some areas which we want to be able to get the minerals out of. But it's interesting, that those are both parts of the primary productive sector, and the government has said, yeah, we recognise that in isolated examples, mineral extraction will win over the protection of highly productive land. When the benefits are really there, it's really worthwhile having.
Last page. Okay. Paragraph 39, kind of the middle of that paragraph. You referred to the previous consenting has enabled unavoidable effects to be managed by significant natural areas are able to be successfully managed to produce good outcomes. In general, is that, I take it, being by offsetting?
It's a combination of offsetting and biodiversity compensation. You'll appreciate that I'm talking about a history of a mine that's gone for 30 years. 30 years ago, we had never heard of biodiversity offsetting. It's turned up, in the intervening decades. And so the techniques that we used back then were less, I suppose, rigorous in the early days. But it was much more based on expert opinion from ecologists about what was going to produce a good outcome and over what time frame, and those sorts of things. We now have these more sophisticated tools. Hasn't seemed to reduce the arguments between ecologists one jot, but they still, we now purportedly have these tools which are more useful. They don't always work or produce the right kind of outcomes, and so in reality what happens is that for complex applications like this, my experience is that applicants need to use a combination of, if you like, more structured biodiversity offsets, but also things that don't qualify as offsets, but also produce good results. So you end up with a package of measures, some avoidance, some mitigation, some offsetting, some compensation, and overall you have to form a view as to whether or not you're going to end up with a net benefit for the values that we're interested in.
Can I just forewarn you that when we get to those chapters and you're addressing us, can you walk me through the RMA changes that have been made to recognise that? Because I'm old enough where when I was practicing, the Environment Court was still debating whether or not it was reasonable or lawful to actually have those sort of conditions in resource consents. I know that the Act's been changed since, but if you could walk us through those statutory.
Yes, sure.
Thank you.
Thank you.
Thank you very much.
Thank you, sir.
Been very helpful. That brings us to the Waitaki District Council. Am I on the wrong day? Oh. Thank you. Am I on the right side? Lisa, I'm sorry, I'm on the wrong day. I'm on the wrong. Okay. Right. Okay. No, we move on to legal.
So part 1, chapter 2. So we don't have any legal preliminary issues to raise. So we will call the 42A author, Lisa.
Thank you. I'm just wondering, Lisa, just while you're setting up, etc., we might as well have a break, right, and tea, and let you set up, all right? We'll have a break for 15 minutes.
Yeah.
I've got one. No.
I keep. Give you one shortcut. Please, someone's grabbed one. I know.
Have you already got this?
No, it's the first time you would have seen it.
I don't have one.
Thank you, Ms. Horton.
Kia ora, ko Lisa Hawkins tako ingoa. Thank you, Commissioners. I have just sent round an opening statement which I have prepared, which is really a high-level summary of the sections which I think are still in contention in relation to Chapter 2 of the Section 42A report, and that relates to the introduction and general provisions of the proposed RPS. If I've not discussed an issue considered either in my Section 42A report or my supplementary evidence in this statement, then I've considered that either these issues have been resolved or the remaining issues are insignificant. So points remaining contention, and I've gone through these as per the subheadings in part 1 of the RPS. In relation to the forward or mihi, the amendment to include reference to the community in playing a role in the development of the RPS was a recommendation of my Section 42A report. Through the evidence, the reasoning for this approach has been supported by submitters, however, alternative wording has now been proposed. I have looked at that alternative wording and I'm of the view that the updated wording is appropriate and still maintains the intent of the original recommendation I made. So at this stage, I'm generally not opposed to the new evidence that has been presented. In relation to the purpose section of the RPS, contention remains around the emphasis and the purpose of well-being of the community and society and environmental management generally within the RPS, and specifically questions remain around whether the terminology that has been used, being the protection, restoration, enhancement and use, whether that gives full effect to Section 5 of the RMA or whether actually use, development and protection is a more appropriate and more aligned. Whether the following inclusion from my Section 42A report aligns with Section 5 of the RMA and the requirement to provide for health. I note also that there has been some support for this inclusion from my Section 42A through evidence that has been submitted as well. Next point, C, is the statement within the purpose that the RPS sets out to resolve issues over time inconsistent with Section 59 of the RMA and the requirement to achieve integrated management. And there continues to be a desire to see food production specifically added to the 3rd paragraph of the purpose. Moving on to the description of the region and the general statement that's provided in the RPS, a consequential amendment to the general description of the region relating to the historic and cultural values was supported in my supplementary evidence. Submitters have provided support for this in their evidence, but they have also suggested alternative wording that would more correctly refer to Māori more generally rather than Aitahu. And at this stage, I'm generally opposed to that amendment. In relation to description of the region in natural character and landscapes, the reference to, and in particular the amount of unmodified land and water within the region remains in contention. In relation to description of the region and coast, reference to the Catlin as an area important to Kaitahu ki Murihiku was sought in submissions within the general description of the region. Evidence has now included specific wording in relation to this, with the suggestion that this update better fits within the coastal section. I've reviewed that, and at this stage, I'm generally not opposed to that evidence that has been submitted. And then there's still a matter in contention in relation to cross-boundary matters where submitters have sought clarification regarding whether the 3rd dot point of the cross-boundary matters listed applies to both natural and physical resources, and a request remains to broaden this dot point to apply to both of those. So that's, I guess, it's a high-level summary of those points that remain in contention for this part of the RPS, and happy to take any questions or queries from the panel.
Thank you.
No, not really. Any questions, Lisa? I know I had you on before about the discussion we're having today, but I see the changes that kind of recognise that I guess my point around the original word, when you're using percentages of GDP and stuff like that, one, it's kind of just one snapshot in time. But the wider issue with that is that we're not actually really dealing with like construction and stuff like that, because they come after all those activities that actually use the resources. Mr. Brass mentioned the university hasn't come along and demanded to be recognised with. My way of thinking is that slightly different to the users that are asking to be recognised, because they are using probably 90% of the land base of the region. And it's not just GDP that they generate, it's actually the exports overseas, which is not really recognised in those sorts of statements. But I think what you've done here is an improvement. So that was just a general comment following on to the social and economic wellbeing sort of arguments that have been going on, or discussions, I should say. So that's all. Thanks, Mr. Chair.
Thank you. Right.
Yeah, no, I don't.
The only question I really want to go through is just to get clarity in terms of when we come to deliberate and make decisions in terms of what has come out of your report, which was dated 27th of April. Have all of the recommendations you've made in that report been picked up as annotations and included in the what we're about to receive, which is, or well, even the 11th of October version?
There is one that I just picked up literally half an hour earlier, which isn't from my 27th of April. It's actually from my supplementary evidence.
Yeah.
And that is in relation to paragraph 5 and 6 of my supplementary evidence, which was 11th of October.
Right.
And it relates to that point, which is a consequential amendment from Ms. Fenmore's recommendations on the historic and cultural values chapter. I have just noted that that sentence at the bottom of paragraph 6 has actually not been included in the 31 October version of the RPS. So that is something that I can address in, or me or Ms. Fenmore can address that in our reply report.
Yeah.
But everything else, as I'm aware, has been picked up in those updates.
And just looking at your summary here, and thank you very much for that, that you've given us today. You've used wording such as where are we? The specific questions remain around, but if you look through your report from April, there's a number of occasions where you'll say, I do not recommend this, or I do not, or I recommend its rejection, or something along those lines. So are these ones extra to those, or are they just the highlights and major issues?
They're the ones that have come out of evidence. So and in those instances, like in paragraph 4, I think most of those ones that I've got there, I have actually said that the question still remains. So in that instance, my section 42A report recommendations, I'm comfortable still with those. I don't think that what's been put on the table by the submitters in their evidence has at this stage has me minded to change perspective on that. So yeah, and where I have been minded to take on board what has been put forward in evidence, I've noted that in this in this latest statement. And I guess I just note that because this isn't introduction and general provisions, is that the reason why I guess I've used that the wording of at this stage I'm generally not opposed, is because it does cover broader issues that may be addressed through future proceedings in the hearing that may require me to go back and look at that.
It's an interesting turn of phrase, isn't it? I'm generally.
Yeah. I think Commissioner Cubitt's point is an example. Exactly. But I think Commissioner Cubitt's point is an example of that if there was recommendations that changed the focus of the RPS based on some of the arguments we've been hearing over the last couple of days, then it may cause me to go back and have a look at some of the things that have been put on the table.
Because those things run all the way through.
Yeah, and this section really does set up the reader for for how to, how to go forward with the RPS.
So when you refer to evidence, that's like the last couple of days.
The written evidence that has been submitted by parties,
Some of them may not have got to you in terms of problem checks.
yes, and some which I think may have just submitted written and do not intend to speak to the panel either.
Thank you, Ms Hawkins, and I think that if I'm reading this correctly now, we're at the end of the day, so we'll review at 9 o'clock tomorrow, and so that'll be with Ms Hawkins again.
Yeah.
Thank you.
That may be also very brief.
Yeah, is
And
anyone
just
going to turn up?
forewarning, not that we know of, and also the definitions appear to be related to and addressed in the chapter authors rather than generically by Lisa. So there'll be plenty of time for you to question James tomorrow.
Yep.
So I'll only be dealing with the bits that my chapter 3, section 42A report has dealt with in terms of definitions. So obviously a lot of people have got interest in definitions that sit in topics rather than the general ones. That being said, there are still a few things to point out to the panel.
I should have asked Mr. Crichton while he was here. I didn't notice that, but on definitions, is actually only a gold clear hunter expected?
No, we clarified that with them before because their interest in definitions relates to the urban chapter. So they'll come back and they won't be. They'll come back at the urban chapter to address their issues.
So what about Victoria? Because we're currently saying that she's coming back.
Yes,
tomorrow.
as far as I know, she's appearing.
Yeah.
She was wanting to come in tomorrow.
She didn't really have any evidence.
No, and she supported the definitions, but she wants to be heard, so
Can someone contact her and let her know that she's likely to be very early?
Very early.
And James is still coming.
Yes.
Yeah.
Thank you. Good, thank you very much.
Thank you.
By James, I mean James Taylor.
no, he's not kind of Adams is coming.
James Adams.
But no, James, not James Taylor.
Oh, he's singing somewhere else.
Yeah.
Opening
Well, it can change before dinner. It can change before dinner.
He's going to change into.
Something less.
No.
What would you like me to do? So you guys know where it is.
Yes, I do. Well, I do.
I can pick you up if you want, but it's just it's the bottom bit of the document.
What's it called?
Bacchus.
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 It's
BACCHUS.
Excuse me, commissioners. Could we please just use this opportunity to pick your brains a little bit further, Wes?
You
Just
get in trouble there. Fine. Go down that end of the table.
just about this additional evidence and the expectation around
Turn your
it.
microphone on. Thank you.
Oh, sure. Sorry. Thought I was yelling.
Is the camera still going?
Yeah, should be. We're just wanting to clarify, so when would we, in your minute that you anticipate on putting out may resolve any questions, so when did you expect to put that minute out about the additional evidence surrounding OGLs?
Well, I was hoping to finalise it once I've
Heard from us.
Having said that, once I've heard back from you tomorrow morning,
Yes.
and then finalise that and hand it to Kate, and it will be issued either tomorrow afternoon or on Friday.
Yes.
I had a question about the scope of what's being addressed in the supplementary evidence. Ms Hunter has proposed an objective and a policy in the land and freshwater, land and soils chapter. And that's what we have been referring to as the carve out. It's a policy that includes a framework for managing the effects of mineral and aggregate extraction. And that is the provision I was referring to earlier today when I talked about that carve out versus topic approach. But Ms. Hunter also seeks a range of additional amendments throughout other chapters of the RPS, and I just wanted to confirm whether the reporting office, whether you're anticipating all of the amendments being sought by Ms. Hunter are addressed in our supplementary evidence, or whether we're limited to that one carve out.
No, we'd be expecting, if we can, to receive ORC responses to all of those chapters that are recommended, or where there's a request, put it that way, for a change. The other thing, which I will go back and read the evidence again, just in case I've missed anything, the carve-out policy that Ms. Hunter is proposing seeks to manage the effects of mineral and aggregate extraction in significant natural areas in accordance with the NPSIB, rather than through the RPS itself. But then Ms. Hunter also proposes a suite of amendments to the eco chapter, and I wasn't sure about the relationship. I'm not clear on the relationship between whether those are being addressed in tandem or whether they are alternatives to one another. Perhaps that's something that I should address with Mr. Christensen. I think you should. Thank you.
You